Hello and welcome. Today is the fourth and final day in the pre-trial for the confirmation of charges in the case against former President Rodrigo Duterte at the International Criminal Court. I am John Nery and this is Rappler's special coverage. With me in the studio are Rappler reporter Gyro Bolledo and the co-chair of the Philippine Coalition for the International Criminal Court, attorney Ray Paolo Santiago. We also have reporting live from The Hague, our Rappler senior investigative reporter Leanne Buan and correspondent Michelle Abad. Allow me to note that Attorney RP here was executive director of the Ateneo Human Rights Center for over a dozen years. This was based at the Ateneo Law School, which has just lost its beloved dean, Dean Joey Hofelenia, an outstanding Filipino, a brilliant lawyer, and one of journalism's truest allies. Our condolences to the Ateneo law community. You can join this conversation on the pre-trial hearings by posting your questions or insights in the Justice and Crime chat room of the Rappler app. You can scan the QR codes below. From time to time, we will go through the chat room comments and read out some of them. As in previous days, the hearing started at 10 a.m. in the Netherlands, 5 p.m. in the Philippines. But the ICC live stream has a 30-minute delay. So, reporter Leanne Buan is already inside the courtroom. She did file this report before she went in. Let's hear from Lian.
Good morning. This is day 4 or the final day of the historic pretrial proceedings of former President Rodrigo Duterte. This morning, we will hear the lead defense counsel, Nicholas Kaufman, make his final submission on the merits. It's still being anticipated by the victims' lawyers, waiting to see if Kaufman has a final card or a final trick in his pocket, seeing that yesterday, the victims' lawyers said they were not convinced by the defense of Nicholas Kaufman. They said it was a weak defense. Just to recap, yung pinaka-argument ni Kaufman kahapon ay there is no direct causal link between Rodrigo Duterte and the people who ended up getting killed. That's either there's no causal link between the words of Duterte to the dead person, or there's no any signed order for that matter. For the victims' lawyers, they said it was a weak argument because sabi nga nila, hindi naman daw kailangan ng sobrang direktang pagpapakita ng isang bagay papunta dun sa isang bagay. In the International Criminal Court case law, the judges in the past have also considered links that are not so direct. Isa sa mga tinignan ng mga judges in the past is the element of virtual certainty. Tinatanong doon kung nung nagsalita ba si Rodrigo Duterte or meron siyang pinirmahan na isang Oplan memorandum, meron ba siyang virtual certainty na at the end of it ay may mamamatay or may papataying tao. Para sa prosecution, para sa mga biktima, there is a virtual certainty because he made sure he gave an essential contribution to it. They are citing the logistical assistance, such as the alleged giving out of guns. They are citing the financial rewards for the policemen. They are citing rhetoric of Duterte saying that if you kill, I will not only protect you, but I will also promote you. For Nick Kaufman, there's no virtual certainty, and he gives a statistical overview. He says that kung more than 4,000 yung nasa PRRD list or the alleged kill list, bakit daw more than 200 lang yung pinatay? And he says that's a 5% chance. That's not virtual certainty. And that for the victims is one of the most painful things to hear. They told us yesterday that they felt very belittled and diminished, na para bang ni-reduce sila sa isang numero, sa isang statistic. Today, the prosecution and the victims will also have their chance to make their closing statements as well as the defense before we move on to the final part of the hearing, which is the yearly review on detention of former President Rodrigo Duterte. If we remember, The interim release request for the former president has been denied because according to the pretrial chamber, the risk factors, all three risk factors are present, such as that the risk that former President Rodrigo Duterte will flee or will escape the case. The second risk factor is the risk that former President Rodrigo Duterte will threaten or jeopardize the investigation by threatening witnesses. And the third risk is that former President Duterte has the risk to recommit the crimes as being accused of. That request was denied last year, but in the ICC, every year, nire-review nila kung meron pa ba yung mga risk factors because they do not want to unnecessarily detain a person for too long if there are no risk factors. So that's going to be what we will hear at the very last part of the hearing today. This has been a very emotional 4 days for the victims and their lawyers, especially the human rights lawyers have been with them all throughout this entire ordeal from 2016 when President Duterte launched the war on drugs for the supporters of President Duterte. They say they are hurt by the fact that they are the laughing stock of some of the international community having flown a former president to The Hague. But the hearings represent a moment of justice for the victims, but also more importantly, a moment of reckoning for the Filipinos of where we started and how we got here. This is Leanne Buan reporting live from the International Criminal Court.
Thank you, Lian. We look forward to your live reports later. Gyro, you've anchored the past 2 days of the live coverage and served on the panel of the first day. What else have we seen from The Hague?
Yeah. So far, John, itong days na to na ginamit for the last days, ginamit ito ng defense to present their arguments. Kahapon, si Kaufman, it's a one-man show for Kaufman. Ni-use up niya yung 3 hours niya to downplay the witnesses. Specifically, meron siyang allusion on the witnesses. Hindi niya pinangalanan, but he's referring to former Davao Death Squad members who might be Arturo Las Cañas and Edgar Matubato. He said that, hindi sila pwede at qualified na witnesses just because they were previously part of these criminal enterprise before. Aside from that, isa rin sa pinag-usapan dun sa 3 hours ni Kaufman, isa sa mga pinaka-inargue niya ay yung neutralization. Kasi doon naglalay yung case theory ng defense because the prosecution wants to, emphasize that neutralization means to kill. And that neutralization is the word present in the PNP memorandum which operationalized the drug war of the Philippine National Police. So according to Kaufman, neutralization daw ay walang ibig sabihin because the Philippine Supreme Court has yet to decide on the petition questioning the PNP memorandum. Apart from that, si Kaufman din ay kahapon, inisa-isa niya yung mga supposed weaknesses nitong arguments ng prosecution. Question niya yung mga individual criminal liability daw ni Duterte apart from questioning din yung mga evidence o yung submissions na provide ng prosecution to establish why Duterte's acts fall on the elements of the crimes against humanity being alleged against him. And lastly, hindi masyadong nag-double down si Kaufman on the issue of jurisdiction while a lot of experts say that isa sa mga pinakamalaking argument and bala ng defense ay itong jurisdiction, John.
Thank you, Jairo. Before we turn to Attorney RP, let's hear from Rappler correspondent Michelle Abad, who covers the scene outside the ICC during hearing days. She filed this report.
Good morning. It's a cloudy and windy morning here in The Hague as we start day 4, the last day of the confirmation of charges hearing of former President Rodrigo Duterte over alleged crimes against humanity at the International Criminal Court. This morning, as usual, there's a steady presence of supporters of the former president gathering out here. As you can see behind me, there are signs that they have been using since the beginning of this week that have their usual calls of calling for the release of the former president, as well as their claims over the ICC allegedly assuming wrong jurisdiction or wrongly assuming jurisdiction over this case, and that the case, if it must be if it must be done instead in the Philippines instead of what they call a quote-unquote foreign court. It's a light mood as usual. Usually out here they have their gathering where they bring a lot of food, some drinks that they usually share with the community. And as of yesterday, they have expressed confidence in the performance of lead defense counsel attorney Nicholas Kaufman in defending the defense of the former president. They expressed agreement with the views of the Duterte lawyers that were here, or the lawyers that were brought here or sent here by the Duterte family, that the defense was successfully able to debunk or refute the allegations presented by the prosecution as well as the victims on the previous day or on Tuesday. So, and apart from the merits that they express confidence in, they've also reiterated again and again their views on the jurisdiction issue, that they believe that if the former president must be tried for alleged crimes against humanity or alleged murder, then he should be instead tried in Philippine courts, as they assert that the Philippine judiciary and the Philippine justice system is functioning well. For now, there have been some tensions with the victims and the supporters, or rather the critics of Duterte. Although there have not been any outright tensions or rather outright forms of violence that have occurred here, there have been tensions. For example, yesterday, as we had a mini press conference with the victims after the hearing, there was a visible barricade that was formed from the supporters of these critics, and preventing, for example, some of the pro-Duterte vloggers from coming near. But yes, so far, no outright violence has occurred. There is always a steady presence of security here, not just for ICC security, but the police presence as well. Although it's not heightened, it's nothing too big, as we usually might see in the Philippines when there are opposing groups that are in the same area. But as for the merits, both groups are quite satisfied with the way that the proceedings are going so far. Since the Duterte supporters are satisfied with the performance of attorney Nicholas Kaufman, the victims and the critics of Duterte are also still satisfied that the case still stands. They still believe that the defense did not present any evidence that would absolve Duterte from his alleged crimes. And let's see what happens today as they go through the concluding statements of both sides. But perhaps one thing that the two groups, both pro and anti, is the actual proceeding to trial. While the pro Duterte supporters would say that they think that it might proceed to trial, it's more because of the fact that they believe that the ICC was biased from the beginning. So for the victims, they believe that the trial will proceed because the evidence is strong. But for the Duterte supporters, it's because they think that it was biased from the beginning. So these are the types of views that we're seeing here, that even if the Duterte supporters are hopeful it will not push the trial, they probably will not be surprised if such an outcome would happen, that the trial will proceed. So this is the latest from outside the ICC. This is Michelle Abad, Rappler correspondent.
Thank you, Michelle. We look forward to your live reports later. Attorney RP, in about 9 minutes, the live stream will resume. What are you looking forward to on day 4?
Well, I'd like to see how the defense is trying to chip away the arguments of the prosecution. Mm-hmm. We do know that in criminal prosecutions, the weight of the evidence is on the prosecution. Mm-hmm. So the prosecution was able to show the pattern, the policy, the action, which is the killing, and the inaction or the impunity, which is the lack of the investigation. Mm-hmm. So now, as Jairo mentioned earlier, what the defense is trying to do, based on what Kaufman was doing yesterday, was trying to chip away and create doubts as to the term neutralize, for example. Mm-hmm. We do know that in a document or even in a dictionary definition of neutralize, neutralize could actually be mundane, not necessarily to kill. But if we contextualize it based on what is actually happening, this is what the prosecution has been showing. In fact, the prosecution, of course, who in his or her right mind will put something to kill in a legal document?
Exactly.
Of course, you would use the term that is understandable by those on the ground. But this has further been supported by the reaction of the president by making sure that there's an enabling environment to kill. He would always egg the law enforcers to kill.
Yeah, we remember that well, right? I mean,
We remember
lived-
that
we lived
well.
through this
Yes,
time.
yes. And again, whether there's a doubt as to the causality, whether it's related to the president,
Yeah.
right now at this confirmation of charges, we're just looking at the policy, whether there was a policy. And the elephant in the room here is that there were statements, there was that enabling environment, and there were thousands of people who were killed and no investigations. In fact, there were less than 5 convictions, even criminal prosecutions for killings. So that's what we're looking at here in this confirmation of charges.
If I'm not mistaken, maybe Gyro can correct me, but what we're looking forward to today is there's a 30-minute allotment for the defense to complete its submission on the merits. And then we have the closing statements.
That's right.
Prosecution, victims' counsel, and then defense again. And then after that, an hour for the hearing on the detention. Maybe I can ask both of you, itong last 30 minutes, what do you expect Kaufman to do?
Interestingly, when the opening statement was given, there were a lot of observers saying his arguments doesn't sound to be legal arguments.
Okay.
It sounds like political arguments. And Jairo mentioned earlier that there is this perception that they want the public to hear that there is bias. I mean, these are being mentioned by the pro-Duterte supporters. I just want to point out again, for the interest of everyone, when we talk of justice, we're not equating it to partisan politics. And definitely, there is no Philippine interest in trying to influence the ICC. So I'm saying this because the closing statements may again allude to the political climate in the Philippines. And in a way, the main legal arguments are during the presentation. So the opening and closing statements, they're actually not legal arguments, but just to wrap things up and to create that salvo.
To weave a narrative, no?
That's right.
Which might appeal to the judges. Gyro, what about you? Yung 30 minutes, the last 30 minutes of Kaufman, ano yung gagawin niya?
Yeah, same with Attorney RP, I'm really expecting a speech which is more of like a political speech rather than a legal speech. Nakita natin during the opening statement of Kaufman, instead of really directly raising legal arguments, ginawa niya ay naging political siya. Sabi nga natin, straight out of Duterte's populist playbook, very emotional, very political, very feisty. I've written about it. And interesting lang dito kay Kaufman, baka hindi natin sure kung siya ba ay nag-tone down kasi kahapon when he started his presentation on the merits, nagkaroon muna siya ng disclaimer saying na he doesn't mean to, attack, and it's not personal for the victims. And apart from that, I'm really looking forward to his arguments or his submissions on the issue of jurisdiction. As we know, this is very important because kung paano titingnan ng ICC yung issue ng jurisdiction kay Duterte would affect other cases as well. As we know, napakabata pa ng jurisprudence o ng theory of law dito sa international law, specifically on the jurisdiction. Kaya important because either the ICC will try to make a jurisprudence that will protect the court itself from possible abuses in the future, or papanalunin nila si Duterte in this issue of jurisdiction.
What about the prosecution? No? Nakita natin on the first day, after the opening statement of the defense, bumelta kaagad yung prosecution at the start of the submission on merits. No? They were rebutting some of the points that Kaufman raised. I fully expect na right after the last 30 minutes of Kaufman's submission on the merits, susunod yung prosecution, na I think they will definitely rebut,
Oo. Pero most likely, they will just repeat what they've already said before.
Okay.
Isa-summarize lang nila. And at the same time, they will of course address what Kaufman has been trying to do, which is chipping away and creating that doubt. No? And since Jairo mentioned jurisdiction, for me, maganda yung presentation kasi ni Kaufman on the jurisdiction, di ba? He was trying to create that doubt in the judges' minds na kung ang dami-daming ebidensya, why did it take 4 years? Bakit hinintay pa na totally mawala ang Philippines, na as a state party of the ICC? No? So that jurisdiction is actually a key card that the defense is using. So it's interesting to find out how the prosecution will deal with this as well, no? Kasi that would be the opportunity.
Jairo, ikaw, sa tingin mo, anong gagawin ng prosecution?
Ako more on the, aside from the prosecution, of course, magaling din kasi mag-present sila yung trial lawyers under the prosecution, si Attorney Julian Nichols, sila Attorney Edward Jeremy. Apart from their, closing statement, nilulook forward ko din, John, actually yung sa part naman ng victims, because ito yung last say nila, although, napaka-important ng ICC structure because this allows victims, to take part in proceedings like this. And I think they will use their time, their 30 minutes to respond doon sa mga presentations kahapon ni Kaufman. Mas magiging emotional sila, mas magiging, papakita talaga nila yung narratives, yung mga lived experiences na pinagdaanan ng mga biktima under drug war ni Duterte.
Attorney RP, di ba? Essentially, yung isang argument ni Kaufman, parang calculus of cruelty, di ba? Parang, 5% lang ang namatay. If you reduce it to statistics, yung number of people parang obscures all the violence.
And this is what's unique about the International Criminal Court kasi it creates that opportunity for victims to be heard. And yung mga victims na natin, mga nandito, they are only representative of the thousands. Kasi yan yun lang yung mga emblematic cases. At sa confirmation, piling-pili pa yan. No? Kasi mas maririnig pa natin yan when it goes to trial.
What do you think? I think we'll be starting the live stream soon, but do they need to find Duterte liable at the very highest level, yung indirect co-perpetrator, o pwedeng lower levels of liability and it can still push through?
Sa ngayon, policy lang talaga ang kailangan. Yung sa liability, they would have to just show the link in terms of, it doesn't, as mentioned by Lian, it doesn't have to be a very clear direct link. No? Because the causality, the causal link, would have to be proved later during the trial. But right now, it's the link as to that policy. And it's very clear as soon as Duterte was to be proclaimed as president when he won, May pa lang, there was already a spike based on what he was promising.
Exactly.
And then, that command memorandum circular on the first day of his presidency was already laid out. So it was clear. And then he hammered on that policy. So that causality in terms of the policy is clear. And then the killings, of course, happen.
What about the issue of intent? Pinag-usapan previously, how do you define intent in a criminal proceeding? It's like, it's the consequence, it's the action. How do we square this?
And interesting yan.
Causality and intent.
Because intent is all in the mind. So you can't, of course, you can always claim there was no intention. Ultimately, the judges would have to determine, since they cannot read the mind of a person, you would base it on what actually happened. That's where that link would be looked into. Okay, so if there are these statements, there are those who followed, there are those who were killed, were there investigations? Because again, what we are dealing here, is allowing the most serious crimes of international concern to actually happen. Diba? But if there were accountability that was happening, and this is where complementarity of jurisdiction comes in, we should not be talking about the ICC. Diba? So bakit walang prosecution at investigation, prosecution at kaso na nangyari dito sa Pilipinas?
Gyro, they're using the Kian de los Santos case in two ways, di ba? Yung parang, may nangyari din naman, di ba? But also, parang sinasabi ni Kaufman, is there a direct order from Duterte to say, kill Kian de los Santos? Meron bang mga instances na Duterte, when, from what you remember of your coverage, where yung halimbawa, mga nasa narco list niya, he would waive them and so on, no? May mga namatay doon, di ba?
Alam mo, ang kailangan natin tignan dyan when we talk about the neutralization and the PRR list, talagang case study talaga dyan yung kaso ng Parohinog saka ng Espinosa, the Espinosa and Parohinog killings. If we're gonna look at the affidavit of former Lieutenant Colonel Jovi Espinido in 2024, he said that yung context daw ng neutralization at nung intindi nila doon ay to kill daw talaga. That is the understanding, that is the operative definition of the word neutralization on the ground. Number 2 point nung affidavit ni Espinido ay yung sa PRR list. Sinabi ni Espinido na personally, hinandpick daw siya ni former PNP Chief Senator Bato de la Rosa to go to those places kung saan napatay itong si Espinosa at si Parohinog. So basically, ang sinabi sa kanya ay dinala siya doon to implement yung PRR list at to neutralize itong mga suspects na to. So yun yung sinasabi ng prosecution on how the neutralization worked in the context of the cases under Duterte.
Attorney RP, speaking of sina Bato de la Rosa and so on, yung mga nabanggit na nga, no? Maririnig ba uli natin mga pangalan nila dito or
most likely because they have already been named, no? So ang tanong nga dyan actually is when are they going to be hailed before the ICC? Kasi hindi naman pwedeng highest level lang, di ba? There are those who implemented that policy. So definitely that would have to come into play later on. And we look forward to that kasi ultimately what we're looking for here is justice and accountability. Kaya ng sabi ni Jairo, kung yung intindi ay neutralize is to kill, the higher-ups could have prosecuted. No?
Yeah.
Kung mali ang intindi nung nandun, dapat i-correct yan, not only administratively but through a criminal case. But the fact that nothing was being done means that it is actually sanctioned, being allowed to happen.
Do you think that the judges are aware of what's happening in the Philippines? There are attempts to muddy the waters, no? May mga... Kasi nakita ko yung spokesperson ng ICC, nagre-respond siya. Umaabot kaya yan sa mga judges?
Oo. Umaabot yan, but they wouldn't want to be, to divert their attention over these things that are happening. Alam naman natin na, yun nga, unfortunately, it's being modeled here in the Philippines because it is very much intertwined with our political situation.
Yeah.
Diba? So, sinisira yung trust on an institution. And this is what's sad because here in the Philippines, we're all trying to build credible institutions. But those who might want to have weak institutions, itong gawain nila.
Yeah.
They muddle the issue, they create doubt, diba? They snap out the hope out of the people. No? So the ICC is giving us hope, especially for the victims. No? So here, I don't think na kahit i-muddle nila dito, yung judges, they will do what's supposed to be done. No?
Saka dyan, if I may add, dyan papasok din yung selective thinking nitong supporters ni former President Rodrigo Duterte because nung nandito na si former President sa trial, lagi nilang sinasabi na the local justice system works in the Philippines, bakit daw dinala pa doon? Yeah. Pero hindi nila nakikita yung fact na wala nga nangyari sa Pilipinas, diba? Less than 20 prosecute, 5 lang yung convictions natin. Baka wala na tayong susunod na conviction. And after that, merong re-investigation on the police liability sa 52 cases na inimbestigahan ng Department of Justice ni Duterte. 32 doon ang nasarado ng walang any criminal action. And that's the reality. And that's the sad part here. Nagiging selective sila in their arguments.
Thank you. Now we will rejoin the ICC. The live stream is resuming.
Please be seated. Veuillez vous asseoir.
Judge Motor. Good morning, everyone. I'd like to welcome everyone in and outside of the courtroom. Court officer, kindly call the case.
Madam President, Your Honors, situation in the Republic of the Philippines in the case of the prosecutor versus Rodrigo Duterte, case reference ICC 0121, 0125, and for the record, we are in open session.
Judge Motok, thank you very much. I would like to ask the parties and participants to confirm that the team composition is the same as yesterday's. Good morning, Madam President, Your Honors. I can confirm that indeed the OTP is represented by the same staff members. There have been a few changes over the days, but they are all here. The presiding judge, thank you very much, Deputy Prosecutor. Ms. Masida, for the legal representatives of victims. Ms. Masida, good morning, Madam President, Your Honors. Same composition as yesterday. Finally, the defense, Mr. Kaufman.
Good morning, Your Honors. We remain the same.
Merci beaucoup.
Thank you very much. I would now like to call upon the defense to address the court and to complete their submissions on the merits. We have to add the time that the defense did not use, but you can use all your time. We will have a break at 10:30, and then we will continue in the afternoon. So, Mr. Kaufman, please proceed, and you must respect the Chamber's decision regarding redactions. Otherwise, I will be obliged to interrupt you each time so as to protect victims and witnesses. Mr. Kaufman, please go ahead.
I do indeed thank Your Honours for that consideration. And we did, in fact, have a short version prepared and a long version prepared. So I'll be reading from the long version, and that was specifically so that we could accommodate the redactions that have been so insisted upon, and we respect that, of course, by the prosecution. So I now turn, with respect, Your Honours, to count 2. And this concerns the alleged murders of high-value targets during the presidential period. And before addressing the individual incidents that the prosecution characterises as involving so-called high-value targets, the defence makes a preliminary observation. The term high-value target appears throughout the prosecution's brief as though it is evidence of a coordinated plan to eliminate targets. With respect, that inference cannot be sustained. The existence of a prioritisation category within a law enforcement campaign does not establish a criminal plan. HVT was an operational classification used by law enforcement, and in this sense, it is no different from a similar acronym in another country where I have clients. APOTS, or Australian Priority Organisation Targets. HVT is not a code for an instruction to kill or a witch hunt. It was a prioritisation tool within anti-drug operations applied across regions and units on the basis of intelligence assessments, alleged position within drug networks, or inclusion on watch lists. Classification does not imply selection for murder, any more than it is proof of unlawful intent. The prosecution itself acknowledges the existence of formal operational frameworks, including police circulars and structured campaigns. Within those structures, individuals could be designated high value for purposes of operational attention. Many HVT operations, in fact, resulted in arrest or surrender, albeit some resulted in fatal encounters. For this reason, each alleged HVT incident must be scrutinized on its own evidentiary foundation. When the incidents falling under count 2 are examined individually, the pattern we submit is similar to those incidents falling under count 1. Namely, heavy reliance on insider testimony, wishful and selective reading of police reports, and dubious and tenuous linkage to Rodrigo Duterte. Now, the operations cited under Count 2 were conducted within the framework of the lawful war on drugs, and as such, operational contexts are consistent with planned law enforcement activity, including buy-bust operations and coordinated arrests rather than preordained killings. The evidence for Count 2 incidents consistently shows that the deaths occurred during armed confrontations in which force was used in response to an imminent threat, in accordance with the rules of engagement repeatedly articulated by President Duterte, namely that lethal force was permissible only where life was in danger. Across the Count 2 incidents, there exist contemporaneous documents, whether it be arrest warrants, operational records, or firearms recovery reports, all of which reflect legitimate police operations that escalated into exchanges of gunfire. The general record does not substantiate a theory of wanton execution, yet the prosecution seeks to rely, once again, on the testimony of criminals spilling their hearts with a tacit understanding that they will never be prosecuted. In 4 of the 5 incidents, contemporaneous reports document the recovery of firearms at the scene, indicating that the weapons were used against police and prompting a responsive use of force. In incidents 12, 13, and 14, the operations were authorized by judicially issued search warrants. We have diagrams on the screen being shown. I'm not going to stop. They will be presented throughout my presentation continuously, all in an attempt to save time. Those circumstances are squarely within operational legality and fundamentally incompatible with a pre-planned murder. Incident 14 is particularly instructive. 4 individuals were arrested alive. To us, that demonstrates selective and not indiscriminate use of force. In incidents 10, 13, and 14, gunpowder residue was detected on the victim's hands. At a minimum, that forensic finding is consistent with an exchange of gunfire and not consistent with a straightforward execution narrative. And the prosecution and the victim's representatives simply can't have their cake and eat it. They can't say in one breath that drugs and guns were planted on victims and therefore dispute crime scene evidence, while at the same time complaining about the lack of crime scene evidence. Yet the prosecution virtually disregards these objective and forensic indicators in favor of narrow and often uncorroborated insider testimony. This is best illustrated in Incident 10, which rests almost entirely on P1160's assertion that a firearm was planted at the scene of the crime, and the official report fabricated. Yet P1160 expressly accepts that he did not witness the planting of the firearm and merely assumes that it must have happened, before conceding that the firearm may already have been present. Once again, we are in the realm of inadmissible conjecture. We know that an investigation followed that incident. The opening of an inquiry is not consistent with the intention to conceal wrongdoing. Beyond that, as I've just mentioned, the record reflects the detection of gunpowder residue on victims' hands in this particular incident, a forensic indicator consistent with an exchange of gunfire and inconsistent with the witness's testimony, which is notably, once again, uncorroborated. Incident 11. This is the sole incident in Count 2 where direct linkage to Mr. Duterte is advanced. And this linkage rests entirely on voice recognition by an individual who claims to have overheard a telephone conversation and recognized the president's voice. while being physically moved from one location to another. The alleged recipient of the telephone call himself was never interviewed, and another person present, on whom the prosecution relies for corroboration, did not hear the conversation. After all, would it not have been an item of interest to all those present in that specific location that the President of the Republic himself had condescended to discuss matters of such a criminal nature by way of telephone? So the ridiculous assertion stands solely on the word of one single individual. The only other corroborating witness, the one who heard nothing, acknowledged a personal resentment that he harbored for the then President, Rodrigo Duterte, for reasons you will find in PHL OTP 000164220-R01 at 0022, lines 695 to 708. Once again, I can't mention the reasons because it's redacted. Voice recognition in uncontrolled conditions, while being physically moved, and uncorroborated by any forensic or documentary evidence, cannot constitute substantial grounds for confirmation, particularly where it forms the sole mechanism for attribution. Incident 12. This incident relies heavily on a central witness whose credibility is seriously compromised by retaliatory motives he admits to harbouring against Mr. Duterte. This can be found in OTP tab 55 at page 27. Line and another reason that we cannot mention in open session, but which can be found in PHL OTP 000-15167-R01 at page 0008. For this particular incident, the case record demonstrates that this operation was conducted pursuant to a judicially issued search warrant, with operational reports and documentation concerning the recovery of firearms. To display such an extensive contemporaneous record, one would expect the prosecution to produce forensic evidence capable of undermining the reliability of these materials, evidence demonstrating fabrication or inconsistency sufficient to reduce their probative value. None, however, has been forwarded, because none presumably exists. Incident 13. This relates to the killing of Mayor Espinosa, whose name I can mention, and Raul Yap, who was shot in a police cell. The prosecution's case is largely premised on a witness who claimed to have heard but admitted not to have seen anything. Thus, there is nothing in the prosecution's evidence to contradict the alternative theory proposed for this incident, which is that there was a firefight between the victims and the officers in the police station Leyte sub-provincial jail. Nor is there a need to enter into these conflicting accounts, because the prosecution's own evidence exculpates Rodrigo Duterte for responsibility for this incident. Not that he admits any connection to it. After all, according to the prosecution, on 1 August 2016, Rodrigo Duterte gave Espinosa a 24-hour ultimatum to surrender. And surrender he did the following day. 4 days later, Rodrigo Duterte commended Espinosa for surrendering to Ronald de la Rosa, commenting that it was just as well that he did. So if we look at it from the point of view of Rodrigo Duterte, that is where the incident ended, despite Mr. Jeremy exhorting us to believe otherwise. What happened thereafter, as awful as it may be, had nothing to do with our client, and not one witness can say that. The prosecution's narrative in Incident 14, the raid on the house of another person who I can mention, the mayor of Ozmis City, rests exclusively on a witness who, for reasons we cannot explain in open session is wholly unable to provide complete or reliable testimony for reasons that can be found in D36, tab 181, lines 128 to 155, and lines 191 to 212. Contemporaneous documentary police reports reflect that this police operation proceeded pursuant to 6 judicial search warrants, something hardly consistent with a premeditated murder scheme. After all, if the intention was cold-blooded murder, why go to the bother of involving a judge? Official investigative materials also indicate that officers approached the premises, announced the execution of the warrant, and were met with gunfire that struck a patrol vehicle and injured an officer, prompting a return of fire. This directly refutes what Ms. Massiter so categorically claimed on Tuesday, namely that none of the arresting officers were ever harmed during the operations. Transcript. T5, page 44, line 24. In every case, the victim was killed, and none of the arresting officers were harmed. The exchange of fire, as reported, is supported by the fact that gunpowder residue was found on 7 individuals, including on the mayor himself, and a paraffin test turned out positive on the person of one of the victims, indicating that he had discharged a firearm, something totally negating the gun plant theory proposed by the prosecution's only witness. It is also worth stressing that 4 individuals were arrested alive following the operation, and that one of them was subsequently sentenced to life imprisonment after the domestic courts rejected claims of evidence planting. That fact alone is not consistent with a theory of indiscriminate execution, but is rather consistent instead with arrest and prosecution within the boundaries of the law and not indiscriminate use of force. So to summarize, across incidents 10 to 14, count 2, we see absolutely no evidence whatsoever of any attribution to Mr. Duterte on the granular level, nor do we see any evidence of a mutually agreed course of conduct on the upper hierarchical level of government involving Mr. Duterte and his alleged so-called co-perpetrators. The record reflects police operations conducted at unit level, sometimes under judicial warrant. P1166 describes operational discretion resting with the local team leaders and characterizes planned killings as rare and locally motivated. P1066 clarifies that to neutralize, that word which has been heard so often in the last few days, neutralize referred to lawful enforcement, not killing, the prosecution's own witness. The Senate committee report refers to rogue uniformed police. To conclude, the evidence reflects decentralization, not control required under indirect co-perpetration. And for these reasons, confirmation on count 2 cannot stand. Now, I'm going to start count 3. We have until 10:30. I'm conscious of the time allotted to me. So count 3 relates to the Barangay clearance operations during the presidential period. Incident 15 marks the beginning of the Barangay clearance operations. Now, from this point forward, a familiar pattern emerges in the prosecution's narrative. The same modus operandi, to employ Mr. Jeremy's language. Routine buy-bust operations are recast as sham exercises designed to conceal extrajudicial killings allegedly ordered from some unspecified source from above. Mr. Jeremy claims a target was identified through the use of lists. Well, there's nothing wrong with that. As one witness, an intelligence officer, explains in his testimony, the use of lists is a normal standard procedure. Once validation was conducted on a person, X, a file on that person would be created as a result of intelligence operations. Then, so claim Mr. Jeremy and Ms. Croft, the target is murdered and reports are falsified and rewards are paid out. This, Ms. Croft suggested at transcript 5, page 23, lines 11 to 13, is the systemicity of the pre-planned attack. But this is not the case. The defense can point to contemporaneous official records generated across different units or organizations that show clearly that in the majority of these incidents, the evidence reflects legitimate law enforcement operations involving spontaneous and reported exchanges of fire and uses of force subjected to forensic and administrative review. These are not clandestine acts hidden from scrutiny, Madam President, but rather recorded operations consistent with self-defense in the course of policing. And where the evidentiary record supports competing inferences, including the inference of a lawful armed confrontation and the inference of an unlawful execution, well, and with this I will conclude, in dubio pro reo. 10:30.
Merci beaucoup.
Thank you very much, Mr. Kaufman. So I've understood that you would like to use the time that remains to you, and you still have 20 minutes, actually. I understood that you wanted to use that time. Yes, I would, but I'm not so sure if I can conclude in 20 minutes.
C'est possible. OK. Nous essaierons, Madame.
Ouais, donc vous avez la...
Judge Motek, very well. It's still you. You have the floor. Proceed.
Across incidents 15 through 49, the Chamber will repeatedly encounter contemporaneous by-bust or warrant-based documentation, reported exchanges of fire, gunshot residue findings, ballistic testing, immediate hospital transport, internal investigations, and in some cases, prosecution and conviction of officers. Against all of this evidence that you've just seen on the screen here, the prosecution offers single insider accounts of alleged stagings, uncorroborated assertions of weapons planting, and nanlabans, unsupported by any forensic evidence, often speculative, frequently contradicted by the alleged co-participants, or yet, more often, complete silence from the alleged co-participants, as they were never even questioned about the incident. And most importantly, despite Mr. Jeremy's assertions on Tuesday, wherein he claimed that the police reports were repeatedly falsified to legitimate the operations as acts of self-defense, copy-paste reports in which victims were frequently blamed for their own deaths, there is zero proof, none, that the only existing contemporaneous documentary evidence is fabricated or unreliable. No proof whatsoever of this supposed falsification in the entire case record. And on this point, let us just clarify a basic principle, that a state document with the appropriate stamps and signatures and what have you is prima facie reliable, or in other words, it carries a presumption of administrative regularity. And if the prosecution seeks to displace that document and call the entire state apparatus into question, then the burden rests on it to produce credible, objective evidence rebutting that presumption. Bare allegations or reliance on single prosecution witnesses cannot suffice to overcome this presumption of authenticity and correctness, nor should the burden shift to the defense to prove that those documents are not falsified. Now, we do not deny that in some instances the record may reveal unlawful conduct by individual officers.
There's an interruption again dito sa feed ng International Criminal Court. Bago po na-interrupt yung kanilang feed, pinapanood po natin ang last 30 minutes ng submission on the merits nito pong si Attorney Nicholas Kaufman ng Defense Counsel ni former President Rodrigo Duterte. So 3.5 hours po in total ang oras para po sa defense para kumbinsihin ang pre-trial chamber na hindi po tatayo ang mga merits o yung mga pahapyaw po na ebidensya na pinapakita nito pong prosecution at ng mga victims. So ito pong si Kaufman, dito po sa last 30 minutes niya, ang mga binabanggit niya po or ang inaatake niya ay yung count 2 dito po sa charge against Duterte. Count 2 refers doon po sa mga HVT or high value targets dito sa International Criminal Court. Ngayon bumalik na po itong feed ng ICC. Panoorin po natin muli.
People were killed in Bulacan big-time operations, and then went on to refer to this as one single operation in which 32 victims were killed by the police in Bulacan. But what Mr. Jeremy failed to tell you, Your Honours, is that one of the prosecution's own witnesses explained clearly that he investigated these deaths in an official capacity soon after the killings and found that 33 people were actually killed in different municipalities and provinces in central Luzon, but that their bodies were delivered to Bulacan. This was not, as Mr. Jeremy suggested, a single incident of mass murder, but rather an improper aggregate of a series of law enforcement operations over the course of 24 hours, executed in large geographical area, and for which we have no evidence in the case record. There's no evidence on the perpetrators, victims, motives, manner of attacks, methodology, in essence, nothing to link them to an alleged fantasy common plan. Everything is just stitched together enough to give it a veneer of organization. I now turn to incidents reflecting documented armed confrontations. And as mentioned when I first turned to this count, the documentary record, which has not been displaced by any evidence proffered by the prosecution, reflects attempted arrests, resistance, and responsive use of force. And you've just seen some of the documents up there on the screen. Let's turn briefly to Incident 17, for which the prosecution has relied on a witness who stated that the planting of evidence was an open secret in the locality and province more generally. However, another witness, working in the same locality, P1208, states otherwise, that he was never involved in illegal operations resulting in deaths, was not aware of extrajudicial killings disguised as lawful operations, and confirms that there were no standing orders to kill. The operational objective, he explains, was arrest. Lethal force only when the circumstances required it. And you can find this information in Defense tab 96. And we see this pattern again and again and again. In Incident 40, for example, P1131, who worked with the individual alleged to have shot the suspect, stated clearly that the killings occurred only in circumstances of lawful use of self-defense. That can be found at Defence tab 74, and you can see it on the screen as well. This type of testimonial evidence is also corroborated by documentary and forensic evidence. Incident 15. The prosecution again resorts to its usual pro forma narrative of staged killings or nanlabans. But what it has not done, of course, is prove this. Whereas I urge Your Honours to look at the screen, where you can see detailed documentary evidence about how this incident came about, and I summarise: a spontaneous exchange of fire after the suspect discharged a firearm, ballistics testing of the officer's weapon, affidavits by the police officers involved, and formal review and investigation of the officer who fired his weapon. Now, I'm not going to sit here and bore you with all the evidence we have on every single one of these incidents, but what I will tell you, Your Honours, is that we have this type of forensic evidence proving attempts, arrests, armed resistance, and responsive and sometimes disciplined use of force in no less than 13 incidents. I don't know where Mr. Butoyan got the idea from that there's no forensic evidence left in the case record. And may we remind you, Your Honours, until the prosecution proves otherwise, which it has not, these state documents remain prima facie, authentic, and reliable. For incidents substantiated by a single witness narrative and unconfirmed by alleged co-participants, I refer Your Honours to no less than 9 incidents. One prosecution witness, P1160, is the sole testimonial evidence for at least 3 incidents, while another 6 incidents are premised entirely on the testimony of P3. Now, what's interesting about these incidents is that P3 alleged that he was only one of a group of 3 or 4 perpetrators, and these other perpetrators are actually also prosecution witnesses. Yet none of the other witnesses corroborated his version of events. Not one. A couple of incidents alleged by the prosecution appear on its own evidence to be unrelated to drug enforcement, and thus questionably part of the fantasy common plan or organisational policy. For this, I would refer you to incidents 31 and 41, which involved targeting of 2 individuals, again, because of non-drugs related conduct. I'm not sure whether I can mention the type of conduct without revealing the identity, so I shall refrain from doing so. The prosecution has not presented any evidence to substantiate any nexus to anti-drug operations in either of these incidents. And for this, I refer you to D36, tab 158, at page 4. On the perpetrator's own account, the trigger for the killing was a personal grievance relating to property damage. There are numerous incidents against unidentified or improperly identified victims. The victim in incident 45 is described as a minor, just as in incident 38, another incident on which Mr. Jeremy focused on Tuesday. And, by the way, on the subject of the killing of children, of course it ticks the right boxes for the prosecution insofar as it pulls the heartstrings. But apart from Kian de los Santos, the prosecution has not, despite its emphasis on children, presented to this chamber during these proceedings any evidence that even one victim, apart from Kian, in its 49 incidents was a minor. No birth certificates, no corroborative evidence, nothing. While incidents presented as involving minors are indeed grave, Article 61 requires proof, not emotion. It is for the prosecution to prove that the children were involved in these incidents, and not for the defence, once again, to prove a negative. Now, this evidentiary deficit extends even further. The Bulacan Provincial Office provided a certificate indicating that it had no record corresponding to the names of the victims, whose names have been redacted on the slide, which we will show you. Okay, but we'll pass on. But their names have been redacted. And these are alleged police killings, yet no operational report. Indeed, no contemporaneous documentation whatsoever has been produced. So on what does the prosecution base its claim that these individuals were murdered by the police other than P3? The prosecution relies almost exclusively on the account of P3 echoed by P8. And this is rather ironic. Does the prosecutor claim that P3 is corroborated by P8 when the source of P8's information is in fact P3 himself? Bootstrapping logic, once again. The alleged direct perpetrator, P1201, stated during his interview that he had never participated in an operation involving a child. The other officer allegedly present during both incidents, P1131, was never questioned about these events by the prosecution. And that omission, we submit, is not neutral.
So we have a disruption in the transmission from the ICC. Let's all be patient. Let's wait for the resumption of the transmission. But right now, what's happening is that the defense counsel is using the extra time that he had saved over from yesterday's session to rebut or to offer evidence against count 3. Is that right? Attorney RP, wait, I think we have our transmission back.
Of a centrally designed OTBT-based common plan, because they quite clearly fall outside of that plan. And it does not reflect what the prosecution on Tuesday described as the systematic features of a national network operation. Instead, according to P3, the motive was personal financial gain through the sale of bodies. And if P3's account is accepted, it reflects opportunistic actions for personal gain of the most macabre kind. As held in Al-Hassan, an opportunistic act committed for personal profit without more falls outside the common plan. Now, just to finish up quickly on the issue of identity, in Incident 43, even the alleged perpetrators are not identified. Without identification, the Chamber cannot assess their institutional affiliation, chain of command, or attempt to make any possible linkage to Mr. Duterte. One more thing, Your Honours. The prosecution focused for some time on Incident 23. I can mention his name, Mr. Benjamin Vizda. Mr. Jeremy displayed compelling footage of Mr. Vizda's arrest and then the Vizda was taken away on the motorcycle. The fact that while handcuffed, he attempted to grab the gun of one of the policemen, leading to a struggle and prompting the motorbike to fall over and the policeman to shoot Mr. Vizda twice in self-defense. and that this PNP report appears to be corroborated by another prosecution witness, whose testimony fully aligns with the substance of the police document. Mr. Jeremy claimed that the PNP reports were false, relying solely on the allegation of one witness that the scene was staged. This witness claimed that the handcuffs were removed from the victim, that the body was loaded on the tricycle a few minutes after being shot and then brought to the hospital. However, his account is contradicted by the very picture the prosecution has shown you on Tuesday. Indeed, it appears that the prosecution is submitting documentary evidence which undermines its own witness's testimony. As you can see here, handcuffs are on. The body is on the ground rather than on a tricycle. Photojournalists are also present. This contradiction was even noted by the prosecution's investigators at the time of the interview and was put to the witness. And when confronted by the investigators, what did that witness say? I don't know if I can. The prosecution must still establish vertical linkage to Mr. Duterte. Or has the prosecution, 2 minutes left, not be satisfied? And finally, with regard to count 3, the prosecution's witnesses themselves concede that there was no formal approval process. Targets were selected without validation, officers acted for personal reasons, and decisions were taken locally. All of this destroys the assertion that there was a mutually agreed common plan. I will elaborate. P1160 claims hierarchical transmission of policy within the police, while simultaneously acknowledging officers' autonomous killings for personal motives. Those propositions cannot comfortably coexist. P3 explains that certain officers acted outside any common plan and for opportunistic reasons. See Incident 38. In Incident 49, P1207 attributes instructions to local officers without evidence of communication or direction from higher authorities. And most significantly, P1207 P1207 states after a certain death, once again abiding by the redactions, Tokhang operations and killings ceased. This indicates, Madam President, Your Honours, that dependence on specific individuals, not an enduring organisational policy. A system-wide common plan cannot depend on the continued presence of a non-fungible local official. And with this, I conclude.
Judge Motok, thank you very much, Mr. Kaufman. All the arguments on the merits have been heard. We will now break for 40 minutes up to 10:30. And after we return, we will continue with the closing arguments or submissions, starting with the OTP. Thank you very much. Court is suspended.
Thank you, and we're back. We've just heard the final part of the defense submission on the merits. Your reactions, Attorney RP and then Jairo?
I think before the extended time, kasi di ba binalik yung time na na-save niya kahapon, sinamarize na niya kung ano yung anchor ng defense nila. Sabi niya, in dubio pro reo. Ibig sabihin nun, when in doubt, we must rule for the accused. And that was what Kaufman was trying to do in this case. No? Una, pinapakita niya, wala raw common plan. Kasi kaya niya pinapakitang walang common plan, pinasok niya yung idea of an opportunistic activity. Diba? Meron siyang sinight na case law ng ICC na pagka yung opportunistic activity na yon, yung mga local ang involved, walang kinalaman yung principal, no? Kasi walang commonality. Second doubt na pinapakita niya dito ay sinasabi niya na these are all legitimate operations. Kasi pinapakita niya, yung ebidensya ng prosecution, uncorroborated. Whereas, itong sa defense, they are official documents. No? Merong police report, he's citing paraffin test. Third way of creating that doubt was showing the inconsistencies, allegedly. No? Sinasabi niya, yung sabi ng prosecution 3 witness, hindi consistent with prosecution 8. Pero yung prosecution 8, yung information niya galing sa prosecution 3 witness. No? So pinapakita niyang allegedly merong inconsistencies. And lastly, yung sinasabi nating he says, she says.
Okay.
Sabi ng prosecution, ito. Pero sabi ng defense witnesses namin, ito. No? Sa akin lang, again, this has to be scrutinized and appreciated by the judges, 'di ba? Kasi hindi natin malalaman ano nga ba talaga yung mga nandun sa detalye, no? So, in short, depende yung judges mag-appreciate of ano bang mas matimbang, no? Bakit natin nasabi to? Ang sa akin lang, no? If we point out, for example, dun sa commonality ng plan, I think the systematic plan of the former president, no, was really to show, parang to shock and awe the Philippines that, this is what I did in Davao. Look how the peace and order situation is there. I'm replicating it for the whole Philippines. So that creating that environment of replication.
Allowing decentralization, yun yung point niya, di ba? Na-decentralize.
Well, na-decentralize pero at the same time parang yung way kasi niya, di ba? Let's face it, takot yung mga tao dun sa Davao kasi you might end up dead, di ba? Yun yung ginawa niyang enabling environment, no? How if there are local authorities na nag-abuse niyan, for me it still forms part of that systematic plan, di ba? And why do I say that it's a systematic plan? Let's take, for example, yung sinasabing opportunistic activity. Merong umabuso. Ang question parati bakit hindi yun hinold accountable? Bakit hindi yun inimbestigahan? Diba? Kasi yun ang problema ang problema dito, sino bang nag-i-investigate ng isang crime scene? Our scene of the crime operatives are under the Philippine National Police. But who are involved in all these anti-drug operations? It's also the Philippine National Police. O sa pagsabihin na natin, di ba sa Philippine law merong presumption of regularity? Ako naman, ang banat ko dyan, ang presumption of regularity ba kapag sinabi nung involved ay self-defense ng laban? Hindi mo na-imbestigahan yun? Diba? Kasi in normal circumstances, no, kung ako, meron akong napatay due to self-defense, kakasuhan mo na ako Diba? At the very least, dapat nagkakaroon ng investigation. Kasi how would you know that it's really self-defense? And that's where the problem lies. Of course, sino ba ang merong official documents parati? Yung police. Pag sabihin mong may paraffin test, ang dali-dali namang magpaputok, 'di ba? Para masabihin may paraffin yung tao doon. So, yun lang yung mga nakikita kong butas dito na I'm pretty sure the judges will appreciate this holistic evidence based on the whole context of what's happening.
Balikan natin some of the points that you raised. No? But I want to ask Gyro. Gyro, you saw the entire submission on merits of the defense, no? Since yesterday. Tapos may nagdagdag na roughly 50 minutes today. Anong takeaway mo?
Ako, ang takeaway ko talaga is, yun nga, bukod sa talagang, Kaufman is really trying to chip away yung mga arguments ng defense. Ang nakita ko talagang pinaka-strategy ni Kaufman in his messaging, aside from the populist, is very, very similar to how Duterte actually justified these killings. For example, if you look at the presentation on the merits today, doon sa pag-atake niya sa count 2, which refers to the high-value targets, minimension niya yung, yun nga, meron naman daw judicial issuance, may judicially issued na search warrants, meron nga daw paraffin test, may gunpowder, etc., etc. Pero hindi pa rin kasi nun, tama si Attorney RP, hindi pa rin kasi nun na sosolusyonan, hindi pa rin nasasagot doon yung main issue is, which is bakit may napatay at bakit walang maayos na investigation. And I just like to zero in on the search warrants na ina-highlight nitong si Attorney Kaufman. If we're gonna be realistic about this, in the context of the Philippine drug war, hindi assurance na yung issuance ng search warrant ay walang napatay. Ang dami natin nakitang recorded cases na in fact, lawful naman talaga yung operations in the first place. But the question is, why did killings happen? Diba? If we're gonna look another step further, tingnan din natin on how these supposed lawful and judicially issued warrants were used against other actors. For example, in the context of activists and human rights organizations, diba? Apart from the drug war, another problem that we have here is that yung mga search warrants na to, ginamit din against these activists, ginamit itong mga search warrants na to para magtanim ng ebidensya, para patayin din sila to justify these killings. Itong mga warrants na to, may warrant yung isang incident nung March 2021 kung saan 9 activists yung pinatay sa Calabarzon. And if we're gonna look at the issue of the warrant in the context of high-value target, for example, in the Ozamis and the Espinosa cases, may question actually doon si Senator Drilon during that time because supposedly the warrants were issued or inuutos doon ng judge na daytime dapat yun siniserve but nighttime siya sinerve nitong mga police na nag-implement ng warrant. So, dapat talaga, I agree with that. Katulad ng sinasabi ng mga lawyers natin, importante talaga that the ICC or the chamber will look into this evidence contextually, how ginamit, anong nangyari talaga, what are the circumstances surrounding these evidence na present ni Kaufman.
Let's join both of your comments. No, let's talk specifically about the Espinosa killing. No, nabanggit niya to No? In fact, sinabi niya, sabi niya, sinabi ni Duterte, mag-surrender ka in 24 hours. Nag-surrender. And then a few days later, pinuri ni Duterte. And he said, that's where the matter ended for Duterte.
Correct.
Reading intent into that, parang gano'n, no? But he died. Parang, unfortunately, he died inside, may gunfight daw. Pwede nating himayin yan. How should we look at that incident in the light of what he just said?
Oo. Ang hindi natin kasi nakikita at alam, di ba? Kasi mahirap naman makakuha ng kasulatan dyan na meron bang quota, meron bang order, mahirap yan But in that environment where merong high value target or targets, no? Itong kay Espinosa, notorious ang kanyang at si Paro Hinog, notorious ang kanilang reputation di ba? So, in the sense, kay Espinosa, magtataka ka, he is in a police detention center. Diba? Paano siya magkakaroon ng baril? Paano siya manlalaban sa loob? No? But even then, that was not properly investigated. So, ang punto ko dito, yung intent, tanong mo kanina, hindi natin makikita yung intent. Kasi nasa mind ng tao yan. Pero the fact na itong notorious person or persons na alam sa drugs, namatay, sinokis, no? And then you couple it with ano ba yung sinasabi ni former president before, 'di ba? O kung hindi lumaban, palabanin nyo. 'Di ba? So ganun yung atmosphere, ganun yung pag-udyok niya eh.
Yeah.
Tapos biglang wala ngang investigation na nangyayari, walang prosecution. So for me there is that common design, no, that they are allowing these killings to happen, no, because that was what was promised by the former president.
Jairo, nabagid mo kanina when Drilon was still in the Senate. Yung sinabi niya, bakit sinerve sa gabi? No? What else is wrong with his parang innocent portrayal of the Espinosa case?
Another problem with the PRRD list, si Kaufman din dun during the submission on evidence, on merits rather, tinatry niya din i-downplay yung PRRD list. Ang sinasabi niya, hindi daw ang argument kasi ng prosecution ay yung inclusion mo doon ay automatic na death sentence in essence. Ang sabi ni Kaufman, hindi naman daw kasi nasa 5% lang naman daw yung napatay doon sa list, which is actually wrong because katulad nga ng hina-highlight ng maraming expert, wala naman talagang number requirement in looking at these killings. But number two, aside from automatic death sentence, tignan din natin yung political context ng FPRRD list na yun. Very, very crucial yun kasi as noted by many human rights organizations and the victims themselves, problematic yun in a sense na ginamit din yung narco-list ni Duterte na yun to attack yung critics ni Duterte in the context of Duterte administration. If we're gonna look at the testimony of former Iloilo Mayor Jed Mabilog in 2024, he was included in that list.
That's right.
He had no proven drug links. He was forced to fly out of the country. He flew to the United States. He sought asylum just because his life was in danger. That is number one. Number two, former Mayor Mabilog said that sinakot siya at sinabihan siya na kailangan niya ituro din yung mga critics ni former President Rodrigo Duterte para masama doon sa narco-list na yon. And he was referring to Senator Drilon, who was one of the staunchest critics of Duterte at that time. So, importante din talagang tingnan natin beyond the, given context. Tingnan din natin yung political context nitong FPRRD list na to, which makes it really questionable and problematic.
Idagdag natin dyan yung, kasi nabanggit mo yung politicians or politics, no? Yung list ni former president, meron din allegedly narco judges.
Okay.
Alam natin, umalma dyan yung dating Chief Justice ng Supreme Court. Kasi sabi nung Chief Justice din, former Chief Justice Sereno, hindi mo basta-basta pwedeng sabihin narco judges tong mga to without proof. So, she stood up for the judges. And we do know what happened to Chief Justice Sereno. The former Solicitor General himself brought co-warranted charges, a case against Sereno, which ousted her from her position. So this is the context. Kaya yung sinasabi kaninang merong warrant, merong buy bust. In short, they're using everything within that playbook as long as they are there in that operation.
We'll get back to this. The hearing will be starting in The Hague again in a few. But here's a report from our Leanne Buan, who was an interview with Kaloy Conde, who was for a long time the Philippine senior researcher for Human Rights Watch.
That was the last presentation on the submission of merits by lead defense counsel Nicholas Kaufman. And for the first time, he refers to or alludes to the witnesses for the defense. He said that they have witnesses to say that there has never been an order to kill, only an order to arrest and make do with the use of force only in self-defense. Sabi niya, that's proof that there's no summary execution and because all of these were orders just to arrest or to incapacitate a perceived suspect or a perceived criminal. Yung highlight nung last presentation ni Kaufman centers on nanlaban. He doesn't say the word as we know it, yung Filipino na nanlaban, but that's essentially what he was hammering on. Ito yung pinarot niya almost the entirety of his presentation. He presented presents police documents. He says, I have a lot of police documents that he says heavily corroborate the claim that itong mga napatay na perceived criminals and perceived suspects ay nanlaban. He makes the use of example of Benjamin Visda na nakita natin sa CCTV na nilagay sa motorsiklo. Pero sabi niya, meron akong mga police report na nagsasabing bumunot siya habang naka-motorsiklo. But we know that those police reports have been disputed in all these years that we've been covering the drug war. Human rights lawyers have presented evidence that these were merely copy-pasted. But to talk more about that, we have a longtime journalist, Carlos Conde, who has covered Duterte and Davao City and the Davao Death Squad, and in this time in Human Rights Watch, investigated also the war on drugs. Carlos, while Kaufman was saying, yung pinapakita niya yung police reports, naka-flash. If you don't know anything about the Philippines, iisipin mo, oo nga, may police report siya, but what's the context for the Philippines?
Well, that's exactly kind of the thought that came to my mind una, na tipong, okay, if you didn't know any better, parang wow, it's a compelling argument. But again, I think this is a challenge for anybody who watches this, na kailangan i-contextualize itong mga claim na ito ni Kaufman, because we know, as you pointed out, na itong mga police reports, any police documents during the drug war cannot be trusted fully. And there has been some determination by experts, by lawyers, by researchers that many of these documents are at the very least faulty. At yung iba nga ay talagang, kumbaga, manufacture or talagang problematic. So, ang ano dito is that yung paggagamit ng mga official police document to prove na walang kaso ang prosecution dito, I think disingenuous, but also I think it frustrates a lot of the families of victims kasi nga they lived all of this during the drug war. Yung mga biktima nila na nilalagay sa dokumento na namatay daw sa pneumonia, sa kung ano ng sakit, pero in fact may bala sa katawan. Ito yung mga sampal sa kanila eh. At ito yung tingin ko mahirap intindihin or baka hindi kayang makita ng mga taga hindi sa Pilipinas, yung hindi alam yung nangyayari sa Pilipinas. So ulitin ko lang, hindi pwedeng pagkatiwalaan ng lubos-lubusan ang mga dokumentong nanggagaling sa pulis kasi mga mga to kumbaga mga
it's a polluted
source na siya. So I don't know kung paano i-appreciate ito ng mga huwes dito sa ICC, yung context na yan, but we're hoping na sana i-take into account nila ito.
What were you thinking when Kaufman referred to their own witnesses saying, alam mo wala naman talagang order to kill? Can we surmise that these are also police officers? And if they are police officers, if police officers yung witnesses for the defense, how do you appreciate that, knowing that Duterte and Bato controlled the PNP?
It's ito yung actually nakakagalit dito sa nangyayari dito eh, dahil nga yung mga kapalpakan ng police, yung mga hindi na magandang ginawa nila are being used to defend themselves. Kasi alam naman natin sa Pilipinas yung nangyayari itong drug war, na lahat ng mga hakbang na ginawa ng police were geared toward fulfilling kung ano yung mga in-order ni Duterte, were geared toward fulfilling kung ano yung objective ng drug war. And no matter how they spin this, yan ang katotohanan sa Pilipinas. Now I understand na si Kaufman as the defense lawyer would do whatever it takes to convince kasi ang problema dito, Lian, ang audience ni na Kaufman dito, hindi naman yung
mga
Pilipino at hindi naman publiko. Hindi nga din publiko ng New Zealand. Ang audience nila, yung tatlong huwes na andito. So, medyo medyo limitado yung tawag dito, yung aspect na yun. And yung nakakatakot dito kasi nga, kung dito ka lang sa korte, pakikinggan mo sila at wala kang alam, hindi mo aalamin kung anong nangyayari sa Pilipinas, yung buong context dito. Nakakatakot yung idea na baka makalusot sila dito.
Yeah. Just lastly, before we both head into the gallery, as someone who has reported on the death squad, anong nararamdaman mo na paulit-ulit sinabi that the Davao Death Squad is a media construct and a fantasy?
Well, nakakagalit din, no? Kasi, unang-una naman, totoo naman na media naman talaga yung gumamit ng Davao Death Squad.
The
label na Davao Death Squad, media naman talaga. Totoo yan, nandun ako noon. Nandun kami sa Davao noon. Pero the whole structure ng organisasyon na yan kahit anong tawag pa dyan. In fact, ang tawag kanina Edgar Matubato nung una dyan is Lambada Boys.
As they heard Kaufman saying.
Yeah. Ay yun yung andun yung structure na yan. So, medyo disingenuous yung pag-i-insist nila na walang Davao Death Squad kasi invento lang ng media. Hindi. Yung term lang, syempre, alam naman ng media, syempre, kung ano yung sexy pakinggan, kung ano yung madaling tandaan. Sabihin na natin, na medyo ng konti, tawag ito,
They told the story very well using catchy words.
So, yun ang katotohanan. Pero ang katotohanan is that yung structure ng Davao Death Squad as the killing machine in Davao and then later on sa buong Pilipinas was real and it happened.
All right, we need to go to the gallery. So thank you. We will be back with more updates.
Thank you, Lian. I want to talk about that concept of presumption of regularity. Kaufman did not use that term, pero yung sinasabi niya, contemporaneous police records will bear this out, and so on. And now, Kaloy Conde, has been observing human rights violations for such a long time. He's saying, poison source, polluted source. Wag natin, how should we think about that, yung sinasabi niya? Nabanggit niyo na yan earlier, no?
Yun yung nakakalungkot, no? Kasi gusto sana natin ng mga official sources, government sources, no? But the reality ng context natin sa Pilipinas ay napopollute itong mga official sources na to. So, nabanggit rin ni Kaloy, for example, yung wrong information in the death certificates, no? Kaya ako binabanggit to, no? Kasi baka mamaya gagamitin to ng depensa na sabihin, pneumonia yung cause of death, no? But in reality, si Dr. Raquel Fortun has been showing, no, in autopsies na klaro gunshot wounds. Pero bakit nga ba wrong death certificates?
That's right.
Double whammy for the victims. Una, napatay na yung loved one nila, no, because of this drug war. Pangalawa, karamihan kasi dun sa isang count yung sa mga operations sa Tokhang, they are poor. Hindi nila matubos yung body. So the easiest, kasi pagka nag-interview kami before pagtutubusin kasi nila, kailangan pagka gunshot wound, may autopsy yan. Sinisingil pa sila ng punerarya para dun sa mga medical legal reports. So the easiest way for them to retrieve the body, because they want to mourn, is to just put their pneumonia or natural causes of death. Dapat yan, imbestigahan din yan. Diba? Kaya nga, yung mga police investigators na sangkot dito, kaya polluted, alam nila yan. But yet, they allow these things to happen. So right now, no, when we talk about accountability, how do we now truly rely on official government documents? Yun yung nakakalungkot, no? Kasi sinisira nila yung sistema natin of trusting supposedly government documents.
That's right.
Speaking of polluted sources, Attorney RP and John, the problem nga kasi with Duterte's Jaguar is the access to information. There's a reason why we only have 5 convictions so far from 2016 to 2022. For example, I already mentioned the case of the Bonifacio father and son case in Caloocan in 2016. Basically, the nanay, si Nanay Mary Ann Domingo, siya yung tumulong talaga sa prosecution, sa private lawyers from the National Union of People's Lawyers and Rise Up na mag-prosecute. Nagmamakaawa siya, kinukwento niya each time, nagmamakaawa siya to access police records, blotter, pero hindi siya binigyan. Kaya sila mismo yung nag-case build up at nagkaroon lang sila ng basis for their allegations nung ma-autopsy na ng tama yung katawan nung kanyang mag-ama. That's the first one. Number 2, kaya rin dito pumapasok yung mga independent investigators natin dahil polluted yung mga official sources natin, which is basically the Philippine National Police. Diyan pumapasok yung esensya ng forensic pathologist natin na si Dr. Raquel Fortun. Ang dami nating natulungan na dahil doon sa mga pag-aaral niya, sa pagre-autopsy ng mga bangkay, nakita doon yung mga totoong cause of deaths. Nabanggit na kanina ni Attorney RP. The problem with drug war, kaya wala rin talaga tayong official records as much is because many of these poor families were forced to sign waivers Na kasi ang sisingil sila kapag ipapa-autopsy pa nila yung bangkay. Wala silang pera, ito yung mga taong walang makain. So syempre, kapag namatayan sila, ang kanilang instant na reaction ay, sige mag-waiver na lang ako, lagay mo na lang dyan pneumonia. Kahit ang kinamatay naman talaga ng anak ko or ng asawa ko or ng kapatid ko ay binaril sa drug war ni Duterte. Let me cite the case of Leanne Buan. In 2025, nanalo ang first ever case sa Pilipinas na may correction of entry sa death certificate. Si Leanne Buan, 9-year-old siya na napatay siya noong 2016. Yung family niya na forced na mag-sign ng waiver na ilagay ay bronchopneumonia sa death certificate. Later on, na-realize nila na parang hindi tama to. Kasi namatayan na nga tayo, inagrabyado pa tayo. Kaya humingi sila ng tulong sa mga organizations, pinare-autopsy nila yung bangkay ni Lenin at napatunayan doon na namatay siya because of gunshot wounds. Kaya nag-file sila ng petition sa court at grinant naman ng court yung correction of entry doon sa death certificate. And after 9 years, na-correct yung entry ni Lenin from bronchopneumonia to gunshot wounds. That's the reality, John, and attorney, dito sa tinatawag nating polluted source. Yun talaga yung nangyayari sa bansa natin. And ito yung mga taong inagrabyado na, napilitan pa sila na even them ay magsinungaling about the supposed deaths of their loved ones.
How can we make the 3 judges in the pretrial chamber 1 appreciate this context? What can the prosecution do?
And this is where the voices of the victims actually come in.
Okay.
No? Kaya nga dito ang ganda nung model ng ICC kasi yung prosecution and defense very legal yan, clinical. Prosecution, they have to make sure that the elements of the crime are proved. Defense, create doubt, chip. Pero how can we now really hear how it affected the victims, what really happened there? And this is where we have our legal representatives for the victims bringing in those voices. We heard Attorney Gilbert Andres, for example, in his excellent way of being able to show what were the thoughts of the families of the victims at the time. What did they have to go through? How they felt. Because essentially, sabi nga ni Kaufman, we can't rule based on emotions. That's right. On a legal proceeding, you can't rule based on emotions. No? But you cannot negate the victims here. No? So the role of the prosecution and the defense, bahala kayo dun sa legal strategy. No? But here are the voices of the victims. What really happened? And that will help contextualize these legal proceedings.
May sinabi din si Kaloy Conde na tungkol dun sa DDS. As a media construct, no? Sabi niya. Well, it was the media that picked it up, but the reality is there was a killing machine.
Correct.
Right? And there have been witnesses. Do you think? Of course, it wasn't today, no? It was in yesterday's hearing where he talked about the mayoral period. No? Do you think that Kaufman was able to successfully seed doubts in the DDS narrative? Wala namang parang ganyan.
Kahapon, sinasabi niya, ang tagal-tagal, no? Ang tagal-tagal na yan. Kanino ba yung source nyo? Kay former CHR chairperson Laila de Lima. Yun yung point niya no? Na sabi niya, yung sinasabing mga bodies dyan, this is how he was creating doubt, no?
World War II.
World War II bodies yung mga yan. Yung walang proper forensic, no? Yung mga tinapon sa dagat, baka may bodies dyan, pero malay ba natin if it is related, no? So, again, this will fall under the admissibility appreciation of the judges. Pero that was the narrative of Kaufman yesterday, trying to direct the attention of the judges. Parang ang gawain kasi nila dito. Ultimately, in a case like this, it's a pre-trial. Kanina nag-uusap kami ni Jairo. This is already a preliminary presentation of evidence. Not the full range of evidence, but you need to be able to prove that there are substantial grounds to proceed to a full-blown trial. No? But in any case, pwede naman i-submit lahat to ng documentary evidence, object evidence, no? But the prosecution and the defense, what they're trying to do here is direct the attention of the judges. Saan yun dapat mong bigyan ng concentration? Paano mo titignan yung ebidensya? Kaya si Kaufman, sinisira niya yung concentration. Parang create niya yung doubt. Oo, pag tinignan mo yan, no, consider mo rin na baka ba ganito o ganyan o nagko-conflict o tignan mo rin tong ebidensya namin. So this is what's unique here. Plus the voices of the victims, of course.
On the mayoral period na tinanay na, i-atakihin ni Kaufman, meron siyang sinabi doon na may conflicting siyang sinabi doon actually. On some parts of his submission, sinasabi niya na fictional lang daw ang Davao Death Squad. But on the latter part of his submission, sinabi niya na dapat daw ay hindi bigyan ng weight ng court yung evidence or yung testimonies na pinoprovide ng mga self-confessed na DDS members. So make it make sense. You're saying na walang killing machine, but you're acknowledging that they were part of a supposed criminal enterprise. Number 2, sinabi din ni Kaufman dun sa kanyang presentation na wala daw evidence corroborating or other narratives or information corroborating supposedly yung deaths under the Davao Death Squad. But if you're gonna look, na-mention na kanina ni Attorney RP, in fact, under former Commission on Human Rights Chairperson Laila de Lima, inimbestigahan niya yung supposed killings under the Davao Death Squad. And apart from that, may mga early narrations na rin tayo and narratives na nakuha from reports, independent reports like the Human Rights Watch. Yung Human Rights Watch, isa rin yan sa mga organization na una ring tinignan at dinocument itong mga killings under the mayoral period. And hindi pa natin sinasama doon yung mga local reports of the local media in Davao City and in Mindanao. So basically, well-documented itong killings na to as far as, these documentations are concerned.
Nabanggit mo yung make it make sense, no?
Yeah.
Walang criminal enterprise like the DDS, but ito mga criminals that you're using as witnesses. I want to ask Attorney RP, maybe he can also weigh in, Gyro. Ano ba ang status ng a person who was involved in the killings turning, into a witness? Parang the way Kaufman treats it, parang dapat hindi pansinin at all.
Hindi, kaya nga in a trial, no? Kaya meron tayong mga cross-examination na nangyayari because this is when you're able to test the credibility of a witness.
Okay.
Kasi kung ang logic natin ay involved ka, hindi ka na pwede mag-witness, nasa na yung mga whistleblowers natin? Diba? How will we treat them? No? But at the same time, you always look at the whole context. You test the credibility. Case in point, no? Kanina na-mention si former chairperson ng CHR, Laila de Lima, naging senador siya, naging chair siya ng Senate Committee on Justice and Human Rights. Ginamit niya yung platform na yon to put a spotlight on the killings, no, when it all started. But talking about the context, we all know what happened to her afterwards. No, not only was she kicked out of her position, she was also incarcerated by alleged witnesses who are also in the bilibid.
That's right.
So we're not seeing that. Sila mismo nga, government at that time was saying, hindi porket mga nasa bilibid yan, hindi na sila credible, no? But those testimonies were tested in a courtroom. No? So here, this is what we are also pointing out here. No? We're not seeing, because we're blind as to who are the witnesses at this point, what are they actually seeing. But from that policy angle, for the confirmation of charges, it's clear that the prosecution so far has established that pattern, has established that policy, has established that there are deaths, has established a culture of impunity. No? So, malamang to magpro-proceed to sa trial ang tingin ko.
Parang si Kaufman, parang ang assumption niya is that dapat may minutes. Di ba? Parang it's all legitimate. So for instance, may yung one example niya na wala naman kayong makitang ma-prove na vertical link to Duterte, except to that one instance na narinig daw no, ng isang tao. Pero that's only one person. So he's saying, you gotta prove there's this link directly to the top. And yet, in this particular instance, biglang, ridiculous. It's only...
But look how he attacked that, di ba? Kasi sabi nung nakarinig, sabi ni Kaufman, hindi naman in-interview yung kausap mismo, di ba? So parang that's how he's attacking the credibility.
Yeah.
Pero yun nga yung pagdating dun sa credibility, that's best suited in a trial.
You've covered the war on drugs extensively, no? We have heard Duterte, give the orders, right?
Yeah. Actually, doon nga sa, for example, ang linaw-linaw doon sa Las Cañas affidavit, the 192-page Las Cañas affidavit submitted to the International Criminal Court, ang linaw-linaw doon that the kill orders directly, came from Duterte himself or coursed through the handlers. Sometimes, allegedly, according to Las Cañas, some of them went through to the supposed co-perpetrators and then saka dumaan doon sa mga gunmen. So, malinaw na malinaw talaga na may mga ganitong orders na binigay si Duterte as far as itong mga testimonies na to is as far as yung testimonies na to are concerned if we're gonna look at the Las Cañas and Matabato affidavits.
I wanted to coming from that yung issue nung complementarity 'di ba? Kasi very important itong issue ng complementarity kasi kaya tayo nasa ICC ngayon. Marami ang nagsasabi kasi bakit sa isang international court if our courts are functioning? In fact, ma-share ko, nung nag-withdraw ang Pilipinas from the Rome Statute for the International Criminal Court, we were one of the petitioners that questioned the withdrawal. And during the oral arguments, we were asked, I remember by Senior Associate Justice Marvic Leonen, tanong niya, do you mean to say that the justice system is not working in the Philippines? We have to understand that the justice system, the criminal justice system, is not only the courts.
Yeah.
A criminal case only reaches the courts once there is proper investigation by the law enforcement, once there is proper determination by the prosecution, and once the prosecution brings it to the court. So, for the sake of argument, even if we say that the courts are actually functioning, if no criminal case is brought to the court, there's nothing that we'll talk about.
That's right.
Ang tanong, who heads the executive department that controls both the law enforcement and the prosecution? And this is why that complementarity angle now comes in because of the lack of evidence, because of the investigative evidence, the lack of, ito nga, puro allegedly, sabi ni Kaufman, official documents, everything is above board. Pero that's the whole point. There was no honest-to-goodness investigation. And that what led us to where we are right now. No? So, this is where we have a forum at the moment to look at what was that culture of impunity that was happening, particularly for the executive department. We can't remove the whole political climate at that time. We've talked about former Senator Laila de Lima, what happened to her. We've talked about former Chief Justice Sereno. We've talked about the killings of high-valued targets, mayors, I'm not saying that they are good persons or but they got killed, even if there are alleged warrants. So that's what we're dealing with at the moment, and that's why we're here before the ICC.
Speaking of justice system, John, kailangan din natin intindihin talaga yung realities on ground beyond yung sa context na na-provide na namin kanina pa ni Attorney RP. Importante din tingnan natin yung ano ba yung mga nangyari talaga under the Duterte administration. Speaking of prosecutors, alam nyo, covering the drug war and talking to the victims, talking to their lawyers, marami talagang ugong-ugong for the longest time na may mga prosecutors na takot mag-prosecute ng mga police because tinatakot sila mismo ng police or natatakot sila sa boss ng mga police. who in essence is si Duterte, di ba? Being the chief executive, chief executive. Ngayon, na-prove yung claim na yon or na-prove yung mga ugong-ugong na yon in 2025 when former Justice Secretary and now Ombudsman Boying Remulla confirmed na talagang nangyari talaga yon under the Duterte administration. In response yun ni Remulla doon sa tanong ng Senate kung bakit pinadala natin sa ICC itong si Duterte. Former Justice Secretary himself said na hindi suitable ang local justice system natin to prosecute Duterte at that scale because of those realities na nakita natin. Number 2 na reality natin, yung supposed, mechanisms natin for accountability like the Ombudsman under Duterte, it did not work also in favor of the victims. For example, the Bonifacio case in point, apart from pursuing criminal actions against the police, the family also pursued administrative sanctions against those police, and they can do that under the Ombudsman or through the Ombudsman. But what happened? The police were exonerated. That's why, although they won in the criminal aspect of their case, yung kanilang question or yung kanilang appeal para doon sa admin sanction na inexonerate yung mga police on the admin part ay still pending pa rin ngayon sa Supreme Court. Yun yung reality natin. The mechanisms didn't work and the local justice system was not really suitable to prosecute Duterte.
But I was struck by Kaufman's difference in approach to the question of institution or organization behind the killings. Pagdating sa Davao Death Squad, wala yan, fantasy. Doesn't exist, fictional. Pagdating sa PNP, presumption of regularity. Of course, he didn't use that. Were you also struck by that? I mean, parang ano ang sa nakikita mo, attorney and Jairo, ano yung theory niya of how it happened? So there were killings. Nangyari lang? People were inspired to take out their guns and kill people?
Oo. Yung sa Davao kasi, vigilante yung pinapakita niya doon. No? And this is where he was pointing out that that's beyond the control of Duterte when he was mayor. No? So, yun yung pinapakita. That's first. Second, pinapakita niya rin doon, where's the evidence? Yes, there are claims, but where are the bodies? No? Where are the forensic reports? Aalalahanin natin na at that time, it was really a challenge na highlight nga lang yan dahil because of former Senator Laila de Lima. But at the national scale, you can't hide everything like that, no? But you can take advantage of a broken system. And this is where that broken system comes in. We were talking about independent forensic investigations. In the first place, that's the whole challenge. We should not be talking anymore about a separate independent forensic investigation because we should rely on our independent investigations being done by our government offices. Pero yun nga yung fallacy How can there be independence when ang pinaka-boss mo sinasabi, ito ang policy, no? And then that scene of the crime operatives is under the police. Ang pinaka-malakas dun sa presidente, the chief of police at that time.
Okay. The live stream has resumed. We're listening to the prosecution's closing statement.
And part of the chief of police's job is to kill thousands of people. It's not a surprise that the police reports don't reflect that. If they decide to murder Mr. Espinosa and Mr. Yap while they're held in jail, it's not surprised that that can be done when Mr. Duterte appoints the head of the Department of Justice. Similar, he talked about, again, I'll get to it, talked about neutralize. And how that is a neutral word and needs to be taken in context. I'll come to that a little bit later. But again, there's evidence in this case, some of which Mr. Jeremy went through in his presentation, that neutralize meant to kill. Whether he is correct, or whether we're able to prove it beyond reasonable doubt is another issue. Whether we're at substantial grounds is clear. We are. And I just say, again, responding to his argument about the documentation, that it's not unique to this case. In war crimes trials, crimes against humanity trials, where the very top leadership are the persons on trial, and when they're committing their crimes, they don't put it in writing often, let's go out and commit a crime. Mr. Kaufman will know this because we both worked together at the ICTY. During the trials for Srebrenica and the other Bosnian Serb army crimes, the VRS, every single order that turned out to be criminal, virtually every single order, had in the order from the General Mladic down the chain, respect the Geneva Conventions, treat prisoners of war properly, treat civilians properly in accord with the Geneva Conventions. That was in virtually every order, and it didn't mean anything. It was boilerplate as part of their cover-up. I'll move on to some of his points from yesterday now. He spoke at length in the beginning about Article 7.1 and an alleged problem or inconsistency with the al-Hishri case in our definition of the civilian population in this case. The law is very clear. All that Article 7.1 requires is that an attack is directed against any civilian population. That term, any civilian population in 7.1, is not limited to populations defined by nationality, ethnicity, or another distinguishing feature of that nature. It's a question of fact to be decided by the trial chamber. We have set this out, paragraphs 17 through 20 of our DCC. It is not particularly complicated. It is not blurry or ambiguous. We stated that alleged criminals in the Philippines are the civilian population, which are the object of the attack. That's a factual issue. So the position taken in the al-Hishri case, which is different, obviously completely, factually to this case, is irrelevant. Second, the issue in al-Hishri did not concern the definition of the civilian population. It was about the nexus requirement under Article 7 and whether it is necessary for victims of the underlying acts or crimes against humanity themselves to be members of the population. It was a different issue completely. And we have defined the population in this case. That just reminds me of what he said today at one point. Oh, well, these victims weren't necessarily related to drugs or the war on drugs. Read our brief. Read the DCC. It makes it clear that it's criminals, including drug dealers, drug pushers, drug users. The incident I went through, incident 3, in my presentation on Monday, I made it clear the victims there in Davao were alleged thieves. That is why they were murdered by Mr. Duterte. Very quickly, he complained or spoke about well, no, I'm going to skip that, Your Honor. It's not important. Moving on, he also made yesterday multiple comments that were inaccurate about the common plan alleged in the case. First, he said there was no direct evidence that even two of the co-perpetrators met in person to discuss the plan, the common plan. Legally, there's no requirement that they do so. However, factually, what he stated was incorrect. We have brought evidence of such meetings, and they're in our pre-confirmation brief. I won't go through it, but if you look at paragraph 27 and the items cited in footnote 135 of that paragraph, it sets it out. I'll come back now to the meaning of the term neutralize in the context of this case. It's open to interpretation in the abstract, but my friend, in trying to persuade your honors to take the view that neutralize didn't mean anything nefarious, quoted statement from Chief Ronald Bato de la Rosa, co-perpetrator de la Rosa, that neutralize did not mean to kill. That was at T006, page 31, lines 2 to 11. So it's been criticizing the credibility of our witnesses. Cites the police chief to say, the police chief who signed CMC 16, to say that neutralize is a neutral term that shouldn't be taken as showing any criminal intent. But we set out in our brief multiple witnesses for the mayoral period and for the presidential period who will testify that to neutralize means to kill. That's again set out in the brief, paragraphs 6 and 24. I'll read out just one example. This is ERN PHL OTP 000-15390-R01 at 0011, lines 345 to 346. Question of this insider witness. Okay, and the words eliminate and neutralize, what do they mean? Witness's answer, kill. You have to kill, whether it is a legitimate operation or not a police operation. So all of the dancing around about the term neutralize doesn't rise to the level where we would not be meeting our standard for confirmation today. One more example, my friend talked about it today. This is incident 13, in which the murder victims were Mayor Espinosa and Raul Yap. As we showed on Tuesday, Mr. Duterte, I won't play the video again, identified Espinosa as involved in drugs and said that he should be shot on sight and tracked down like a dog. And Mr. Kaufman said, yes, but Mr. Espinosa surrendered. And then tried to portray the murder of Espinosa in a jail cell as legitimate self-defense. In a jail cell, there's a shootout. The telling point here, as we said on Tuesday, transcript 5, page 10, lines 9 to 10, in the PRRD list, it was brought up, I believe, in the presentation. These two victims of incident 13, they are noted as neutralized on the list, not on the day they are arrested, not on the day they go to jail. They're marked neutralized on the days they're killed. So they were neutralized at the time they were murdered, per Mr. Duterte's government at that time. As I said in my submissions on Monday, right from the beginning, we acknowledge throughout his speeches, Mr. Duterte and some of his co-perpetrators, I used the term allies on Monday, referred to shoot to kill and self-defense, and that they sprinkled in these references to due process and legality. The evidence shows, as I said, that was only to build a veneer of legality, to create an impression of legality, and to give his lawyers something to say when this day came. And that's exactly what has happened. Mr. Kaufman has gone through, repeated these, when he can, as some kind of mantra that supposedly exculpates his client. Does not. As I said, this is the lawyer Duterte trying to build in a defense in case he was ever held to account for his crimes. The facts can't be denied by these sprinklings. He ran a death squad in Davao that he created. He ran it for over 20 years before he became president. His promise was to kill thousands, and he did. So it doesn't matter how many times he tried to throw in a caveat. And again, as I said, this is not uncommon in crimes committed by powerful figures. They try to build in a defense. One point Mr. Kaufman made yesterday, again, showing why this case is ready to go to trial and should not be dismissed. He refers to witnesses providing what he says is exculpatory evidence. He misstated these witnesses by saying they were OTP witnesses. They're not. We're not relying on them, but their statements are disclosed. We found these witnesses and interviewed them through the process that he portrays as somehow corrupt or biased or I don't know what. They provided exculpatory information, and we disclosed it. And that is somehow meant to say that this case should not go to confirmation? I mean, these witnesses are interviewed under 55-2. They're as suspects. Is it really unusual that when you're interviewing somebody who was involved in the crimes, that they say, I didn't do it? Does that mean that this case should not go to trial? Again, we go to trial. He can call those witnesses. The trial judges will listen to his witnesses, listen to the OTP witnesses, and then decide if we've proven our case beyond reasonable doubt or not. I'll speed up a bit, Your Honors, because I don't want to go over my time. He made a small point I just have to respond to, making a call. Why aren't there more investigations? Why aren't crimes being investigated now in the Philippines? Well, his client prevented all that by withdrawing the Philippines from the Rome Statute when he thought he might be prosecuted, thereby ensuring that we would not have jurisdiction after a certain period. Another point. My friend is trying to kind of have it both ways on how Your Honors should treat Mr. Duterte's utterances, his speeches, his words. On day 1, T0004 at page 30, lines 18 to 19, my friend said, Duterte's word was his word and the people knew it, end quote. Yesterday, worried about his client's confessions, that's what they are, he said, quote, this is at T0006, page 7, lines 5 to 7, he said, quote, one cannot rely on anything coming out of Mr. Duterte's mouth. All right, that's good to know if he ever decides to testify, and for his representations on interim release, that you can't trust a word that comes out of his mouth. But beyond that, as I went through on Monday, 3 times under oath, Mr. Duterte said in committee hearings, I have a death squad. Is Mr. Kaufman saying that his client is a liar and a perjurer who has no problem lying under oath? Limited use statements. I won't go through all the, frankly, nonsense that we heard about limited use statements. What I want to make clear, he tried to create an impression which is just not true. Not one witness has been granted immunity in this case. None. There is no such thing as virtual immunity or whatever he called it. He said something similar today. It's standard practice to use these statements when interviewing suspects under 55-2 who have rights and they do not grant immunity. It just means a statement can't be used against that particular witness. And if they lie during those statements to us, to the OTP, then the agreement is void and they can be prosecuted. And his suggestion somehow that we should not interview the direct killers, Mr. Duterte's killers at the bottom of the pyramid? They shouldn't be interviewed? That's clinically insane from a prosecution point of view. And of course, some of those persons will get limited use statements if their lawyers request them. And finally, we're here in this court to prosecute the most responsible, and the most responsible is his client, former President Duterte, not the people on the ground who committed the killings. They are responsible, but they are not the most responsible. And unlike his client, the ones who have come forward have shown remorse for what they have done. His client, contrary to everything he said in the last few days, the last 3.5 hours, repeatedly admitted committing the crimes we're here for. His killings of his own people, the Filipino people. We saw some of those in our presentations. I'm sorry, I missed one point. He said there was no linkage of the incidents to Mr. Duterte. He said, my friend, not one incident where the direct order came from Mr. Duterte for one of these incidents. Well, he should look at incident 1 of the ones we have charged. And I'm afraid I don't have my cite because I skipped around. But in that incident, the evidence shows that we have a witness who heard Mr. Duterte on the phone, who heard that the order came from Superman, his client's code name and nickname. Mr. Jeremy is helping me. It's at para 89 of our brief, Your Honors. So that was wrong. That is, I just wanted to reply. He said that several times. It's not true. Back to Mr. Duterte. He's proud of his killings. He wants to be remembered for them. Decades of murdering his own people, murdering the children of the Philippines. And he claims that he did it all for his country. He doesn't deny it. He says, as I said early on, it's a necessary evil. It's for the greater good. Doesn't matter how many kids I have to kill. I'll clean up the Philippines. Now I want to play a clip, Your Honors, if we can do that, James. This is, you'll see the beginning. I played just a few seconds of it. I'm going to play more of it now, about 2.5 minutes.
Na ginawa ko man ang lahat sa panahon ko para may konting katahimikan at mapayapa ang buhay ng Pilipino. Ang problema nito, ewan ko kung ang tingin ng ako'y raw yung o ganito na lang. Ito ganito na lang. O sabi ko, assuming na totoo, totoo talaga yung naririnig ninyo. Bakit ko ginawa yan? Para sa sarili ko? Para sa pamilya ko? Para sa inyo at ang inyong mga anak sa ating bayan. Ang higiin ko na lang sa inyo, total, kung ganito man talaga ang swerte ko sa buhay, okay lang, tatanggapin ko yan. Wala tayong
Excuse
magawa
me, counsel, you have 5 minutes left.
Hulihin tayo kung ikulong tayo. Kaya lang, meantime, mag-contribute kayo, baski $5, $10, para paglabas ko sa prisuhan, pagawaan ninyo akong monumento katabi ni Rizal. Si Rizal may hawak na libro eh. Akin.
Okay, what did we see there? This is essentially Mr. Duterte's farewell speech. It was made on 9 March last year, 3 days before, as he says, he was apprehended. He was not going to surrender, apprehended and surrendered to The Hague. What did we see there? First, I won't repeat it, shows total, utter contempt for this court. Second, referring to, quote, his sin, end quote, he says, assuming that all the talk you hear is true, assuming it's all true, why did I do that? What is the talk that's all true? It's obvious. After he says that, he says, problem is, they think I'm the one who, and the crowd cheers. Again, he doesn't say it out loud, because he knows he's on video, he doesn't want the words there, assuming I'm the one who killed all these people. So he makes a little motion, crowd goes wild, and he smiles, because he likes that after he's made that statement. What innocent person has ever said, assuming I committed all these murders, it was for a really good reason? That's what they would like you to believe, that he doesn't mean it. And he says he did it not for himself, not for his family, but for the Filipino people, and it's obvious what he's talking about. He's talking about the murders. Again, the ends justify the means. Again, for him, the murders are a necessary evil for the greater good, as we heard right at the beginning of his career when he's teaching police officers to plant evidence. The end of that video, what does he ask for? He says, I might go to jail, what can we do? But when I get out, contribute money so there can be a monument erected of him when he's released from jail. And he describes what he wants that monument to be to himself, former President Duterte. A statue, not holding a book like the national hero Jose Rizal, but holding a gun. 3 days before his transfer to The Hague, this old man, you could see it still up there. What does he want to be remembered as? The man with the gun. And he's just taken credit for killing his own people. It's time for him to take responsibility for these crimes he brags about and glories in. Can we go to the next one quickly? I think I got about 3 minutes. James. This is tab 146.2. It's a quote from a speech on August 16th, 2017. What did he say? Quote, I know I will have my own downfall. I cannot be president forever. I know that they will demand to answer for all this dead. End quote. And he was right when he spoke those words. He must answer for the dead. The victims demand it, justice demands it, and for purposes of confirmation, the evidence demands it. We have proven it to the level for this to be bound over for trial. We ask you to do that, Your Honors. Thank you.
Merci beaucoup, Monsieur
Thank you very much, Mr. Nichols. We will now go to the closing statements of the common legal representatives of victims. You have up to 12:30.
va présenter les arguments en conclusion de cette audience.
Maître Andres will present the closing statements. George Motok, you have the floor, Mr. Andres.
Your Honors, good noon. In our closing statement, the common legal representative for victims will first rebut the defense submissions. Then we will provide the larger context why the confirmation of the charges against Mr. Rodrigo Roa Duterte is vital for the victims, especially in relation to their communities and the Filipino nation. Your Honors, listening to the defense submissions on the merits yesterday and today was to me like listening to the parable of the elephant, wherein they want us to see only the parts of the elephant: the trunk, the tusk, the ears, the head, but not the whole of the elephant. We must look at the whole context. Madam President and Your Honors, it's also my duty as the common legal representative for victims to express the views and concerns of the victims. As they're watching these proceedings, they have stated, and when they heard the defense effectively submitting that the chamber should ignore the systematicity and the widespread nature of the attack, it's like their murdered loved ones are being murdered again. Having conveyed that as my duty, we will address the defense submissions in seriatim with 10 rebuttals. First, on Mr. Rodrigo Duterte's speech, defense argued yesterday that, and I quote, relying on the former president's speeches as a means of proving criminal intent is impossible. I am quoting the transcript of yesterday at page 4, lines 5 to 6. But the victims convey that the Philippine context is vital in knowing and understanding the criminal intent and impact of Mr. Duterte's speeches. Under the Philippine Constitution, the executive power shall be vested in the President of the Philippines. Whatever the President publicly states is policy. And in the Philippine cultural context, when there is strong respect for those in government positions, especially the President, as head of state and as head of government, the words of the President is to be obeyed, no matter what. Especially for Mr. Duterte, he has portrayed himself as a man of his word. The defense even emphasized, and the prosecution also referred to this last Monday, that, and I quote the defense, for President Rudy, his word was his word, and the people knew it, end of quote. And that's the transcript of Monday, page 30, lines 18 to 19. The defense even stated that, and I quote, Rodrigo Duterte was and will always remain a unique phenomenon, end of quote, referring to the transcript last Monday at page 30, line 14. Mr. Duterte was and is indeed a unique phenomenon in the public and vulgar way in which he used his words to dehumanize the victims of his anti-drug campaign, to excuse their murder, to shape the Filipino psyche to his murderous rhetoric, and to predispose the government agencies under his presidency to follow his words as presidential policy and as orders. And the records show that every time Mr. Duterte exhorts the killing, the murders of alleged drug users, people are murdered all over the Philippines. To our second rebuttal, we rebut the defense legal theory in its Thursday submissions vis-a-vis count 1, which contains 9 incidents of murder during the mayoral period of the suspect. The defense argues concerning count 1 that this is allegedly, and I quote, hardly widespread. And I'm quoting the transcript of 26 February 2026 at page 6, line 23. We strongly disagree. Widespread refers to the scale of the attack. Courts and commentators interpret it through several indicators, such as the large number of victims, the killings, the deportations, rapes, or other acts affecting many people. Geographical spread, wherein the violence occurs across multiple towns, regions, or a broad area. The long duration, the sustained attacks over time, rather than isolated incidents. The mass impact on the civilian population. The attack affects the population as a whole, not just a few individuals. The focus is on the quantitative magnitude. The attack is large in scope or effect. Systematic, on the other hand, refers to the organized nature of the attack. It is about how the violence is carried out, where there is pattern or methodical plan, repeated similar acts showing coordination, organizational policy or approval, wherein there's the involvement of the state or organizational structures, use of resources, logistics, weapons, or personnel deployed in an organized way. Regularity in pattern, not random or spontaneous, but structured. This is a qualitative criterion. The attack is carried out according to a plan, policy, or organized pattern. In the Nataganda case, the trial chamber has held in 2019 that, and I quote, the assessment of whether the attack is widespread is neither exclusively quantitative nor geographical, but must be carried out on the basis of all the relevant facts of the case. End of quote. In fact, in Nataganda, the trial chamber once again emphasized that, and I quote, the term systematic reflects the organized nature of the acts of violence and the improbability of their random occurrence. It refers to the existence of patterns of crimes evidenced by non-accidental repetition of similar conduct on a regular basis. End of quote. In reviewing the evidence in the record of this case, the only reasonable conclusion is that the attack against the specific group within the civilian population, individuals perceived as linked to drug crimes, was widespread and systematic. Contrary to the statistics shown by the defense, there is ample evidence about the high number of murders in this case. Third, on the death rate. Based on the 2019 trial chamber judgment on Nataganda, there is no requisite death rate in order to prove crimes against humanity for murder. Fourth, we rebut the defense legal theory in its Thursday submissions, which refer to the chapeau elements of Article 7 of the statute. The defense argues, inter alia, that allegedly, and I quote, this policy did not and could not constitute an attack directed against a clearly definable civilian population. End of quote. And I'm referring to the transcript of yesterday at page 10, lines 16 to 17. We disagree. Since the chapeau elements of Article 7 of the statute provides for, and I quote, widespread or systematic attack directed against any civilian population. End of quote. As the element of crimes provide, and I quote, attack directed against a civilian population in this context, elements is understood to mean a course of conduct involving the multiple commission of acts referred to in Article 7, Paragraph 1 of the statute against any civilian population. pursuant to or in furtherance of a state or organizational policy to commit such attack. End of quote. It is also essential to note that on the targeting of a specific category of civilian population, the pretrial chamber has held in the situation in the Republic of Kenya that, and I quote, the chamber takes into account the information relevant to the status of the victims, their ethnic or political affiliation, as well as the methods used during the attacks. End of quote. The same pretrial chamber in the situation in the Republic of Kenya further held that, and I quote, the issue of whether an act was committed as part of a widespread or systematic attack needs to be analyzed on a case-by-case basis with regard to each particular act. End of quote. Applying this legal principle to the case at hand, we have argued that the evidence on the record unequivocally shows individuals targeted by Mr. Duterte's anti-drug campaign overwhelmingly came from impoverished communities where social mobility is limited and opportunities are scarce. The same type of people in the same type of communities using the same modus operandi were targeted by Mr. Duterte's anti-drug campaign. People from the vulnerable communities, the poor and marginalized, especially in urban, informal settlements marked by high levels of poverty. Thus, we have shown last Tuesday, Your Honors, that Mr. Duterte's anti-drug campaign was really a war against the poor. Consequently, the document containing the charges was not, and I quote, muddled, end of quote, as argued by the defense in the transcript of yesterday at page 8, line 8. Rather, consistent with the chapeau element under Article 7 of the statute, the DCC in paragraph 17 refers to the, and I quote, widespread and systematic attack against the civilian population in the Philippines, end of quote, referring to paragraph 17 in the DCC. While the DCC in paragraph 20 specifies that this attack was against, and I quote, alleged criminals in the Philippines who were perceived or alleged to be involved in drug-related, including production, sale, and use, and other crimes such as theft and murder, end of quote, referring to paragraph 20 of the DCC. The latter, in paragraph 20, is merely a subset of the former in paragraph 17 of the DCC. Again, this framing in paragraph 20 of the DCC is synonymous with the framing in the situation in the Republic of Kenya, wherein police violence targeted perceived gang members. Fifth, the defense yesterday referred to Philippine Supreme Court issuances. And I quote, the defense inter alia referred to, and I quote, Supreme Court of the Philippines in petitions challenging aspects of the anti-drug campaign, end of quote. Referring to transcript of yesterday at page 26, lines 10 to 11. Madam President, Your Honors, I and Attorney Buturian are familiar with these petitions referred to by the defense because we were actually the petitioners' counsels in those petitions. And we actually argued before the Philippine Supreme Court last 2017 on this issue. Nevertheless, the defense critiqued the prosecution's manner of using the quote, Duterte's administration's year-end report for 2017, referring to PHL OTP 0003-3355 or tab 139 for the defense. Specifically, the defense argued that vis-a-vis the, and I quote, deaths of 3,967 drug personalities, end of quote, that, and I quote, these deaths comprise that a fraction of the 118,287 total arrests for drug-related activities, end of quote. And I'm referring to the transcript of yesterday at page 32, line 1. Nevertheless, Your Honor, the same Supreme Court decision or resolutions referenced by the defense has stated with respect to those 3,967 drug personalities who died in the anti-drug operations from July 1, 2016 to November 27, 2017, as indicative of the state policy of extrajudicial killings under the Duterte administration. As held by the Philippine Supreme Court in its notice of resolution dated April 3, 2018, which is PHL-OTP-003-3058, and which is tab 112 for the defense at pages 46. I quote the Philippine Supreme Court. Aside from the OSG's submissions in the present cases, we take judicial notice of the Duterte administration's 2017 year-end report, where deaths in cases related to illegal drugs and the internal cleansing conducted within the Philippine National Police are touted as accomplishments. And Your Honor, the next sentence is emphasized in the original resolution. The government's inclusion of these deaths among its other accomplishments may lead to the inference that these are state-sponsored killings. In the section Fighting Illegal Drugs and subsection Real Numbers, we find the following figures. And Your Honor, I will just quote the one that was in emphasis in the resolution. 3,967 drug personalities who died in anti-drug operations from July 1, 2016 to November 27, 2017. As well as 16,355 homicide cases under investigation from July 1, 2016 to September 27, 2017. 6. The defense referenced, again, the same Philippine Supreme Court resolution. But that same resolution held that nothing else to substantiate the OSG's claim of legitimate police operations. And I quote that specific portion in the Philippine Supreme Court's Notice of Resolution dated April 3, 2018, which is tab 112 for the defense at page 47. The Supreme Court held that, and I quote, apart from these numbers and their bare allegations, there is nothing else to substantiate the OSG's claim of legitimate police operations. The lack of any submission of the required information and documents leads this court to believe that there is no basis to the OSG's claim. It is Hornbook doctrine that bare allegations unsubstantiated by evidence are not equivalent to proof, i.e., mere allegations are not evidence. End of quote. 7th, Your Honor. Again, in reference to the same Supreme Court resolution referenced by the defense, the Supreme Court also held there that the PNP cannot claim presumption of regularity on deaths occurring during police operations. Your Honor, I will quote that specific portion of the Notice of Resolution dated April 3, 2018, which is tab 112 for the defense at pages 47 to 48. The Supreme Court held, and I quote, "The PNP cannot claim the presumption of regularity in official functions because deaths are not supposed to occur during any of their operations. The presumption of regularity in the performance of official duty must be seen in the context of an existing rule of law or statute authorizing the performance of an act or duty or prescribing a procedure in the performance thereof. The presumption also cannot prevail over positive averments concerning violation of the constitutional rights of the accused." And Your Honor, in the next paragraph, all of it is being emphasized in the original. And I quote the emphasized portions. "The Duterte administration's 2017 year-end report states that there were 3,967 drug personalities who died in anti-drug operations from July 1, 2016 to November 27, 2017, and 16,355 homicide cases under investigation from July 1, 2016 to September 27, 2017. This is a total of 20,322 deaths during the Duterte administration's anti-drug war from July 1, 2016 to November 2017, or an average of 39.46 deaths every day. This court wants to know why so many deaths happened, as expressly reported under the section Fighting Illegal Drugs of the Duterte administration's 2017 year-end report. Next, Your Honor. The Philippine Constitution provides for the right of life in Article 3. Therefore, because of that right to life, there is actually no presumption of regularity if a person is killed during a police operation. And actually, the presumption is reversed. It's actually the onus probandi on the police to prove that his or her actions were within the lawful requisites of self-defense. In fact, Rule 15.4 of the 2013 revised PNP operational procedures mandates the proprio motu investigations if death occurs during a police operation. However, Your Honors, despite the at least 3,967 deaths under anti-drug operations, there was no proprio motu investigations for all of these deaths. 8, Your Honor. The defense yesterday referred to the Philippine National Police Operational Procedural Manual issued in 2021. But the same was irrelevant and a non sequitur with respect to how the PNP construed and applied the word neutralize under CMC 16-2016 from July 1, 2016 until March 16, 2019, which is within the temporal jurisdiction of the court. The defense recognizes that the same Philippine National Police Operation Procedural Manual was published in 2021, specifically in September 2021. And it was already after the temporal jurisdiction of this court. Hence, it's irrelevant with respect to this case. 9th, the defense asserted that purportedly the Duterte's administration is, and I quote, intolerant for rotten apple police officers, end of quote. That's in the transcript of yesterday at page 32, line 20 to 21. This is not true, Your Honors. Mr. Duterte's administration has not criminally prosecuted the police officers responsible for the government-recognized deaths of at least 3,967 drug personalities who died in anti-drug operations from July 1, 2016 to November 27, 2017. In fact, the undisputed fact in this case is that the Philippines only investigated at
Excuse me, counsel. You have 5 minutes left.
At most 302 cases. And I refer to the February 27, January 26, 2023 decision of this chamber on the authorization pursuant to Article 18, Paragraph 2 of the statute to resume the investigation. The court here, the chamber has held, the chamber observes that at the time of the prosecution's request, the DOJ panel had referred to the NBI for investigation in case build-up 302 cases consisting of 52 PNP IAS cases, the non-Laban cases, and 250 NPS cases. And in paragraph 39, from the information before the chamber, it therefore appears that the DOJ panel review does not amount to relevant investigations within the meaning of Articles 17 and 18 of the statute. Moreover, the number of cases reviewed by the DOJ panel, namely 302, is very low when compared with the estimated number of killings that allegedly occurred in the context of war on drugs operations. Res ipsa loquitur. Mr. Duterte's administration has not criminally prosecuted the police officers responsible for these deaths. Last, Your Honor. The defense erred when it conflated Ms. Paulina Macida's statement that Rodrigo Duterte failed to prevent or punish with the theory that the prosecution has not charged command responsibility under Article 28. Ms. Macida's comment on the fact that Mr. Duterte did not take steps to investigate and prosecute was pronounced in the context of her submissions on the fact that encouragement of killings through public statements by Mr. Duterte sent a clear message that those responsible need not fear accountability and can act with impunity. Said comment cannot be extrapolated from that context, as the defense did yesterday. We do not suggest that Mr. Duterte should be liable under Article 28 of the statute. We maintain that there is ample evidence for confirming the mode of liability under Article 25(3)(a) as pleaded by the prosecution. Also, we want to emphasize, Your Honors, that there were indeed children murdered systematically under the charges that are being held against Mr. Duterte, Your Honor. And they are not mere collateral damage. In conclusion, the victims submit that the defense has not blemished the prosecution legal theory and evidence as provided in the document containing the charges and the pre-confirmation brief. The victims submit that the prosecution presented sufficient evidence to establish substantial grounds to believe that Mr. Rodrigo Roa Duterte committed each of the crimes charged. Consequently, all charges should be confirmed, and Mr. Rodrigo Roa Duterte committed to trial. Lastly, Your Honor. Your Honor, the victims want these charges to be confirmed because they want to be reintegrated to their communities, because they are still in the shadows of fake news, of fear and of threats from Mr. Duterte's supporters. Hence, it's important, Your Honor, that all of these charges be confirmed against Mr. Duterte so that the victims of these crimes will be taken out of the shadow of darkness into the light of truth and justice. Because in the end, Your Honors, the victims, they're also created in the image of God, and they also believe that the God of the universe is the God of justice. Madam President, Your Honors, thank you for your kind attention. This ends the presentation, the closing statement of the common legal representative for victims. May it please the chamber.
Judge Motok. Thank you very much, Mr. Andres. We will now take our break and resume with the final submissions of the defense at 1400 hours. The hearing is suspended.
You're watching Rappler's special coverage of former President Duterte's pre-trial hearing in the ICC with Philippine Coalition for the ICC co-chair Attorney RP Santiago and Rappler Justice reporter Gyro Bolledo. We just heard the closing statements of the prosecution and the victims' counsel. The hearing is running about an hour late. When the hearing resumes, we shall hear the prosecution's closing statement. But right now, Leanne Buan, senior investigative reporter, joins us live from The Hague. Lian?
You just heard the closing statements of the prosecution and the victims, and I can tell you what was not visible on camera, which is that merong audible reaction yung public gallery when Julian Nichols, the trial lawyer, began to start by addressing his friend, Nicholas Kaufman. They've been addressing that to each other ever since the hearings began. And when he said, I'd like to thank him, and it's the first time he's saying that, because everything he just said just proves this case moves to trial. Meron talagang audible reaction from the public gallery, particularly to my left, where the human rights advocates and the victims are seated. We are reminded that we are actually just at the pretrial stage of these proceedings. The threshold is lower. It's just substantial grounds to believe. So merong pag-sit up yung mga human rights advocates, because we were discussing with each other during break how yung pagpresenta ni Kaufman ng mga police reports to boost his case may be appreciated very starkly differently between Filipinos and for foreigners who have no familiarity whatsoever dun sa kaso. Pag tinignan mo nga naman na pre-present ang mga documents, mga police report, kung wala kang familiarity sa Pilipinas, ay masasabi mong oo nga naman may ebidensya ang defense. So there was also a sigh of relief among the human rights advocates when immediately Julian Nichols said that they will show in trial that these police reports were often falsified. We can remember Nick Kaufman also yesterday saying na yung mga supposedly incriminating evidence against President Duterte have exculpatory parts. For example, the speeches where he says, kill and I will promote you. He will also say, use force only in self-defense. He also said that in the same memorandum in circulars where it says neutralize, it also says follow human rights and the rule of law. Julian Nichols said that in his experience with Kaufman at the International Criminal Tribunal for the former Yugoslavia, ganun din naman, lahat naman daw ng written order na bumaba ay nagsasabi na follow the Geneva Convention, follow the treaty, but that all of them meant nothing because they were merely part of a cover-up. And that's, I think, something that Attorney RP could attest to, because they did a study at the Ateneo Human Rights Center that studied the corrective measures or the corrective circulars that sought to correct the flaws and the legal errors of PNP CMC 16, 2016. And then we moved on, the hearing moved on to the closing statement of the victim's legal representative, Gilbert Andres. Again, yung nag-prompt ng reaction is when Attorney Andres said that the victims want this case to move to trial because the victims want to move out of the shadow of fake news. And that's something that's been a persistent problem since we got to The Hague. The victims are visibly warned. Their advocates and the people assisting them have assembled into some sort of like a voluntary human security, making sure na yung mga biktima ay hindi nabivideohan at napipicturan ng mga taong hindi nila kilala and presumably supporters of the president. Yesterday, like I saw, there was almost an entire human barricade protecting them, and these advocates telling to the supporters of President Duterte na wag na natin silang picturean dahil ma-AI na naman, ma-fake news na naman. So it's been a tense couple of days. It's been a tense week. It's been a very heavy week, emotional week for the victims especially.
Lian, ang dami nga nangyari, no? The last phase of presentation of the defense, anong reaction sa gallery? So the hearing today started with that. What was the reaction in the gallery and among the victims?
yung unang part, yung segment ni Kaufman, mas nakita ko yung reaction from foreigners. They were quite impressed that there were really police reports that being shown. Kaya talagang nag-worry ng koonte yung mga human rights advocates. Kaya nung sinabi talaga ni Julian Nichols that these reports are actually falsified, mararamdaman mo na buti na lang sinabi niya yun, kaagad.
Yung kay Julian Nichols, no, when he played that rather long excerpt, no, ano naman ang impact dyan sa gallery?
The supporters of the president were they had a face that they felt uneasy watching it. Hindi uneasy, parang it's a sad face, hindi sila nakangiti. It's not something na supportive of it, ngumingiti, parang almost boasting of it. Parang makikita mo rin naman na they didn't like what they were seeing, not because they don't like what they're hearing, but because maybe they think that the president is being portrayed in a negative way.
And before we hear from Attorney RP and Gyro, they might have questions for you also. One last question for me. Yung kay Gilbert Andres naman, no? Were you expecting him to actually have more of a legalistic closing statement, 10 rebuttals, no? Which actually were quite important, but was that expected?
Honestly, like for my point of view, whenever we go into these hearings, I really do expect the victims' representatives to just focus on the views of the victims, because after all, that's their role. It's really the prosecution's role to provide evidence. But then again, Attorney Gilbert Andres and Attorney Joel Butuyan can't help it. Sila talaga yung lawyer from day one. Gilbert Andres made it a point yesterday na actually yung Supreme Court petition na sinasabi ni Kaufman, we filed that. That's Danyo and Almora in the Supreme Court. So yung kanilang foreign counterpart, si Paulina Masida of the OPCV, would always say, it's not our job to provide the evidence. That's the role of the prosecutor. But then again, having known center law and Attorney Andres and Attorney Butuyan, they just can't help because they know the drug war case at the back of their head.
Attorney RP.
Oh, Lian, it's nice to see you there and nice to hear from your reaction coming from dun sa gallery, no? I was wondering kasi tayo dito sa Pilipinas, nakakausap natin parati yung mga victims, and I am sure they're very much elated na finally, no, they are being heard, they are being seen, their cases are actually being considered now, no? May mga nakausap ka bang mga victims na syempre ang ayaw nating mangyari din dito, 'di ba? Mga false hopes, 'di ba? Pero essentially, no, ano yung I'm sure happy sila, pero ano ang mga initial reaction ng mga victims nung nakatungtong na diyan, nakita nila yung hustisya umuusad talaga?
RP talaga, nung day one, it's really an emotional, the emotions were running high on behalf of the victims. First, positively, because may nakausap nga ako, parang sabi niya, parte nung kanyang pag-iyak ay pride na Pilipino yung nagre-represent sa kanya. And they said, napatunayan nila na tama yung desisyon ng kampo ng mga human rights advocates na ang pagsalitain ay dalawang Pilipino and not just Paulina Masida. Pero sobrang visible, RP, yung stress nila this last 5 days. I mean, nakausap ko kanina during break yung isa na interview ko sila, and when I interviewed them, I mean, I know these people, right? So okay kami, okay mag-interview, but they just told me kung pwede na bang burahin yung kanilang mga video because the harassment has been severe over the last couple of days, and of course we have to adhere to that request. So yung they're really visibly tired and worn and very stressed. And we know why. We have seen all the harassments and fake news online.
Oo. Kanina nga, pinag-uusapan namin yung mga wami dun sa victims. Tapos na-realize ko nung nagkukwento si Jairo about yung correction ng isang record ng death certificate that took 9 years. Ang realization ko, triple wami pa pala. Ngayon na binimension mo na yung risk sa safety nila. Nakita natin recently yung kumalat na AI photo, no, na ginawang naka-designer bag sila. From your observation there, meron bang mga safety issues dun sa kabila naman? Kasi two sides yan di ba? Kasi meron bang perceived threat? May takot ba dun sa mga supporters ni former President Duterte?
I talked to one of them yesterday, isa sa mga more prominent vloggers with huge following. Parang ang concern lang naman nila ay yung Duterte Street sa harap ng prison complex ay wag nang puntahan kung hindi ka naman sumusuporta sa dating Pangulo. Like that's all they ask, parang leave this space to us. And then I asked them kasi parang sinabi ni Attorney Butuyan and sinabi rin nung isang biktima si Shira Escudero that they're so anxious walking around the city. I myself is also very anxious kapag nagbabas ako at nagcha-champ ko. So I mean, you never know. We were all at a certain extent recognized. So tinanong ko sa kanya na anong nararamdaman mo na yung mga biktima ay natatakot, and they keep saying wala naman silang dapat ikatakot at baka yung threat na nararamdaman ng mga biktima ay perceived lang nila, but having experienced that myself, I wouldn't think that it's a perceived threat. And even then, even if it's a perception of threat, it's still a valid emotion to feel afraid for your safety when you're walking down a city where you know there are a lot of people who do not believe in you.
Lian, earlier I asked Attorney RP, do the judges know the Philippine context? No? I want to ask you, tungkol dito sa mga fake news na that's a form of harassment sa mga victims, do the judges know? Is there a way for the judges to know that this is happening at the very moment the pre-trial is going on?
I mean, they go home and they read the stories, I would suppose. But an interesting note is yung the other judge, the African judge. I met her like 3 years ago during an event celebrating women in the judiciary. That was 2023. And I said to her, do you know that we just ousted our first female Chief Justice, our female ombudsman is also being attacked. So maybe after that conversation, she has a context of what happens in the Philippines. The Peruvian judge is very familiar with our context because kasama na siya sa mga chamber na naging parte ng mga decision sa ating sitwasyon over the years. But that's why sinasabi lagi ni Attorney Kirsty Conti, document the harassment, document everything so that they could submit to the pre-trial chamber kung ano yung nangyayari sa kanila.
Thank you. Gyro has a question.
Lian, I only have one follow-up for you. On the arguments or presentations raised by the prosecution, tapos na kasi ito, basically nag-wrap up na si trial lawyer Nichols. Anong reaction mo? Paano mo i-assess yung kanyang presentation of evidence? Kasi we were talking earlier about it na parang sobrang methodical kasi talagang nilay down yung context na itong si Duterte is a prosecutor, professor of police academy who understands the law, and this is the same person who supposedly understands the law that induced policemen to, para i-trigger yung mga suspect na mag-fight back. And some of the victims are actually, came from less privileged backgrounds. Paano mo i-assess? Anong pananaw mo dun sa overall na present ng prosecution? Iyan.
Again, nung nagsalita si trial lawyer Julian Nichols kanina, we were all reminded that we are not weighing all of this with a standard of reasonable doubt, to convict beyond reasonable doubt. We're really just at a stage where is there substantial grounds to believe that Duterte committed those crimes. And that's why I think it was important for Julian Nichols to show that speech from Hong Kong na parang yun nga, he was admitting that he killed but it was for good reason. And I want to be remembered someone who's holding a gun. So napakababa pa nung threshold, and in my conversations with people who are specialized in crimes against humanity, just the mere rhetoric of saying I killed people, I created this death squad, that's ought to be able to confirm the charges.
Lian, I'd like to ask about foreign media coverage. I mean, before this started, even in UCAN News, for instance, there was the story about the pre-trial and so on. Has there been sustained foreign media interest in this pre-trial?
Yes, as days go by, dumadami yung mga foreigner sa public gallery. Day one was really full of Filipinos, but as days went by, dumadami. I mean, the foreign journalists also asked me for my perspective, also ask what I think. But the common question that I get from foreign journalists is that if the prosecution says Duterte is an evil guy, why are there so much people cheering his name outside the ICC? And honestly, like, I can't answer that. That's why sinasabi ko dun sa mga human rights advocates, baka may sagot kayo sa tanong na yun. Like, if the prosecution says he's a bad guy who killed people, then how do we explain the outpouring of support in Duterte Street, outside of the ICC, and everywhere back home?
Napag-usapan natin to ni Attorney Ted, if you remember, Gyro, on the first day, no? Yung opening statement ng prosecution, parang sinasabi natin na most of what they said, mga DDS supporters will say, yeah, tama yun. Yun yung, kaya namin siya binoto. Yun
ang kailangan para maprotektahan tayong mga Pilipino kasi yun ang sinasabi, ganyan ang kailangan natin dito sa Pilipinas. Yan ang way nila.
And in fact, kahapon nga doon sa submission ni Kaufman, sabi niya pa, this is, if yun daw yung Davao template or Davao model, yung mga Pilipino naman daw yung bumoto noon. Kumbaga, the Filipino people accepted that template, accepted that Duterte will kill for them. That's why he was elected to the highest office.
Lian, one last question. I know that they shortened the lunch time, so I don't know if you've had lunch already. But
yes,
is there anything that we're missing, from that we don't see because we're only looking at the live stream, other than the audience reactions, no?
The lobby is very interesting because you would have Medialdea, Attorney Delga in the same space and close proximity with victims, in the same proximity as paring Father Bert Alejo. I mean, kapag nakikita ko nga silang magkakalapit na hindi ko alam kung titingin ba ako or just look away because it's so bizarre. And then sa ICC kasi revolving door and yung malaking revolving door, in the interest of time, dapat kung marami kayong nandun na, dapat sabay-sabay kayong pumasok. So there was one time I was, because we can only interview outside the court. So nag-request ako ng interview sa mga biktima. Sabi ko, sige, samahan ko na kayong lumabas. But in the revolving door was Medaldea and the ICC guard was saying, go together. And I don't know how to signal to him that that cannot happen. So talagang parang sabi ko, no, it's okay, let that. The cafeteria is also very interesting. Kita mo rin yung awareness sa mga tao kasi parang it's a reunion of the human rights community is what I would say. It's really, uy, nandito ka. With the added novelty of being inside the court, nasa labas lang namin yung ICC pond that we cannot take a photo of. So that's only for her exclusive privilege. But then, hindi mo alam kung yung nasa table, nakatabi mo ay mga supporters ni President Duterte. So I think both sides are trying to really walk on eggshells around each other dito sa lobby ng ICC kasi it's a very limited area for the public and the visitors.
Yes, bizarre, surreal, and also historic. Lian, thank you very much for continuing to report on this extraordinary proceeding. We'll hear back from you, but maybe you can go have a full lunch now. Thank you. Attorney RP, naalala mo ba yung racketeering case against Imelda Marcos and also Ferdinand Marcos? And then Marcos Sr. died. No? Nangyari to sa New York, no? But Imelda Marcos had a terrific defense counsel, si Jerry Spence, right? Tapos essentially, ang ginawa ni Jerry Spence was to say, lahat nung na-prove ng prosecution, kasalanan ng asawa pero patay na. And then of course, it helped that Imelda fainted in the courtroom. The reason I'm bringing this up is that baka naman medyo bias yung lens natin pagtingin, or lens ko pagtingin kay Kaufman and say, populist language, gano'n. But you did point out, he's slowly chipping, and also Jairo, slowly chipping away at the other arguments. Ang worry ko lang is that we shouldn't underestimate him, no? This is a guy who's used to winning in this court.
Yes.
Right? So, katulad ni Jerry Spence, famously, hindi daw siya natatalo, although once or twice natalo siya. He was able to get acquittal for Imelda Marcos. Baka naman, ano kaya, I'm worried that there will be a Jerry Spence moment here.
Totoo yan, John. Last night when I was also watching, that's also my realization eh. Sabi ko, itong si Kaufman, magaling. No? Magaling siya kasi he's really able to create that doubt. And he was pointing out to the judges, ano yung mga titignan nyo na doubtful? No? What are the angles? What are the issues that might create doubt? As a human rights advocate, tama yung sabi mo sometimes we have blinders, di ba? Pero as someone from the legal community as well, no? Ang gawain ng isang defense counsel is really just to create doubt, no? Fortunately for now, we're still at that pre-trial stage. Hindi pa nalalatag ng prosecution yung buong evidence nila, no? So kumuha lang sila ng again representative of what could stand that substantial grounds to proceed to trial. Si Kaufman, right now, he's limited to what is being presented as well by the prosecution because the burden is with the prosecution. Of course, he can present other pieces of evidence, pero ang nangyayari ngayon is he says, she says. Diba? So, ultimately, malalaman natin kung based on how it affected the appreciation of the judges of these pieces of evidence. But if we'll just look at the bigger picture, again, this is where my imement ko yung advocate and legal background. Oo. Policy napakita yung buong policy and the deaths could not be masked. No?
So you're convinced that at least in terms of finding substantial grounds,
yes,
for the confirmation of a trial,
yes,
meron.
Oo, so far kasi right now kanina pinag-uusapan natin ang role ng prosecution is to prove the elements, no, to move. Ang galing na yung legal representatives natin for victims, sila attorneys Joel and Gilbert, also gave the context here in the Philippines. Not only from the voices of the victims. Sabi nga ni Lian, bare minimum boses ng mga victims ang lalabas nila, but they contextualized it. No? So that gives better appreciation, hopefully, no, for the judges. But of course, we still have to listen to the closing statement. But as I said earlier, yung closing statement, ano lang yan parang trying to address some arguments, but the pieces of evidence have already been presented in the past 3 days that they have been presenting.
Jairo, I was really struck by Attorney Gilbert's tack, no, which was to propose 10 rebuttals, ano? Doon sa mga rebuttal, what stood out to you?
Sa akin yung sa Nataganda case na na-mention ni Attorney Andres on the threshold on whether, na-commit ba ang crimes against humanity. Kasi isa yun sa mga inatake ni Kaufman dun sa kanyang submission on the merits to question whether the elements of crimes against humanity are met. Sabi ni Kaufman ay yung drug war naman daw ni Duterte, even if it does exist, ay hindi naman daw inatake ang general population, but only targeted, a sample population, which happened to be the population of alleged drug suspects. So very important for Attorney Andres to point that out, that in the Nataganda case na wala naman talagang death requirement pag nagpa-pertain doon sa element ng crimes against humanity na yun. Kasi on a human rights perspective, it's a way to, to trivialize the statistics, but also on the legal perspective, it's really, brilliant to point that out, that, we're not talking about whether it's, attack on the general population, we're talking about killings, diba? In general. And that's also the point raised yesterday by Attorney Rostogade that, Kaufman actually misread or miscontextualized the meaning and definition of the elements of the crimes against humanity. On my last lang on my end, important din na context yung pinivide ni Attorney Andres on Duterte's influence. The ICC itself noted of Duterte's continued influence. In fact, if we're gonna look at the warrant of arrest issued by the chamber, they noted there, among the reasons or justifications why they issued the warrant was because of Duterte's continued influence even after his term. And it's important that Attorney Andres zeroed on that because importante yung sinabi niya that the word of the president is to be obeyed no matter what. Basically, it just shows that the policemen follow these powerful people and that it creates not just a culture of impunity but also the culture of the mini Dutertes that Attorney Butuyan was talking about in his opening statement.
Yeah, that ties in with what Attorney Joel said. How about you, Attorney RP? Doon sa 10 rebuttals, ano yung that stood out?
Yung last statement about justice talaga ni Gilbert yung nag-stand out. Not because I don't support. Ang galing nung 10 rebuttal statements niya, no? Okay. But I like it that at that end, part of that whole rebuttal is that circling it back to the victims, no? Na he's talking about putting in that spirituality. No, kasi many of the victims, we do know that we're predominantly Catholic as a country. So many of these victims had been supported by the churches, Catholic churches, Protestant churches. No? So when he was talking about the God of justice, and you are there at the International Criminal Court, kinilabutan talaga ako doon. Parang, alam mo yung, ito talaga yung dasal ng mga victims. No? So, I was really very happy that finally they see light. No? So, we're not yet at the trial stage, but this is what we want to give to many Filipinos. No? Not only about this case against the former president, but the essence of justice is really accountability, batting impunity. And if this case moves forward, and hopefully the Philippines would rejoin the ICC again, kasi it's a very concrete message that really crime should not pay, that there should always be accountability, and that we should beat impunity. And that goes with all the different issues that we're facing right now, including corruption.
That was really a powerful end.
Yes.
To an unexpected closing statement, no? Very legal arguments, and then the God of the universe is also the God of justice. Ang ganda ng bagsak, ano? But may sinabi kanina si Lian that really brought home to me how extraordinary this is. Yung sabi niya, pupunta ka sa cafeteria. Parang reunion ng human rights community. But lalabas ka, baka makasabay mo yung executive secretary ni Duterte. I mean, I'm just trying to how do you see that ba? Yung ganitong klaseng opportunity, I guess once in a lifetime opportunity to have different sectors represented in one forum. Parang tinutukso pa nga ni Kaufman na desperate yung mga tao. Yes, they're desperate for a form of justice. Ano? Yeah. Pero parang napaka-surreal na sa kantina, magkaibang tables.
Dito kasi, when we talk of justice in general, justice goes for both ways, for both parties. Diba? We do know that in the ICC, there are those who had been accused, but at the same time, acquitted. Or later on, even on appeal, gets acquitted. No? And when we question, justice ba yan? Kasi may mga victims, ganyan. No? From that legal perspective, justice is all about evidence. And for me, when ang realization ko, pagka nagkakatagpo yung defense, yun sa prosecution, victims, lahat sila, yan naman ang sigaw hustisya. No? So, I I think we have to find a way to be able to rely on having faith in institutions na if we really want justice, the best way for us to be able to attain justice is to present our case and evidence in that proper forum. Diba? So sa akin, nandyan sila sa forum na yan. Diba? So the least that everyone could give each other is respect. Diba? Kasi otherwise, if we're going to disrespect institutions, no, we're eroding again our values as a people. So, yun yung kailangang matutunan natin as Filipinos.
Jairo, your take on this surreal moment?
Yeah, actually, parang round 2 na to eh. Kasi the first thing that this happened actually was in 2024 during the Quad Committee hearings.
Oh, that's right.
Yeah. So, nung time na yon, hindi kasing surreal or unrealistic nito. Nung time na yon, yun yung time, first time, in a long time na nakita ng mga victims si Duterte in person. There was a time that Duterte attended the hearings. Alam mo, nung time na yon, talagang kami ni Lian, we talked to the victims, and then may isang anecdote nga doon when Lian talked to one of the victims, Mary Ann Domingo, na umiyak siya, nag-breakdown siya when she heard Duterte talking about, na walang remorse, Duterte na mayabang pa rin, Duterte na walang remorse pa sa katawan ng kahit konti. So that really, nalungkot din kami ni Lian on behalf of the victims kasi parang they were really looking forward to that moment, the time of reckoning. Maliwanag sa kanila na at that time sa Quadcom, malayo pa yun. Hindi pa yun. Kaya very important sa kanila itong ICC part na to kasi kung nung Quadcom, one step to justice sila, dito much closer to justice. Malayo pa kasi pre-trial hearings pa lang to. Wala pa tayo sa full-blown trial. Wala pang conviction dito. Obviously, confirmation of charges pa lang to. Pero this is very important to the victims. That's why I want to highlight that. Alam mo, when we talk about respect and dignity as Filipino people, we should also respect the victims. Kung ano yung mga sinasabi nila against Duterte, those things are valid because namatayan sila. Those things are valid because they have proved, they have evidence to showing that pinatay yung kanilang mga kapamilya on drug war. Nakakalungkot lang na we are reduced to a nation na kine-question natin kung ano yung mga bag ng mga victims na nandun, kung ano yung suot ng mga victims, yung family ng victims na nandun. Nakakalungkot that, victims had to defend their existence there when in fact we should be questioning why the state allegedly use it resources to kill our own Filipino people.
Nakakalungkot tsaka nakakagalit. Thank you, Gyro. Thank you, Attorney RP. Joining us live from The Hague is correspondent Michelle Abad. Michelle?
Hi, John, and to the rest of the panel. Good afternoon. It's the midday break. I know that you've just talked to Lian, and she just described a little bit of the arguments presented from the prosecution. Today, I'll be going into a little bit more of the manifestation given by CLRV representative Gilbert Andresano. As expected by some of the human rights lawyers today, this was really a day it was a chance for the prosecution and the victims to rebut the defense, who had the floor the entire day yesterday. So a Filipino lawyer, Gilbert Andres, spoke for the CLRV, or the common legal representative of the victims. And during the course of the hearing, he said that the victims said it was like their loved ones were being murdered all over again. So he began, of course, expectedly speaking for the victims, but he did go into a 10-point rebuttal that was actually quite complimentary for the prosecution. So here he was not only acting as a voice for the victims, but he also really made and took the time to refute the defense's claim that Duterte's policy was not widespread, not systematic, not above ground, and not targeting the poor. He outright used the time to really refute these claims from the defense. And it's also notable, I found it personally notable, that this Attorney Andres, speaking as a Filipino lawyer, opened with the Philippine context. He first noted that everything that comes out of former President Duterte's mouth back then as chief executive of the country, everything that came out of his mouth was policy. And it becomes Filipinos will obey. So he also delved into this legal principle of presumption of regularity, which is a little bit of a technical legal term, that assumes that everything that official forces do is lawful and procedurally sound. So Attorney Andres made several counters to this in some examples that I will list now. So in 2017, there was a document that was shown by the defense as well, 2017 year-end report of the Duterte administration, which had the statistics on deaths that occurred in police operations. And Attorney Andres said that this implied that, or there was an inference of state-sponsored killings. And deaths are not supposed to occur in official police operations, which makes this questionable, especially in the terms of regularity. He also cited the no less than the Philippine Constitution, which has the guarantee to a right to life. And so there is no presumption of regularity if a person dies in a police operation, an official police operation. And the defense also said that Duterte did not tolerate bad apple police, but his admin at the same time did not prosecute many of the policemen who ended up being the killers that ruled out the orders of the drug war. And he also refuted the claim from the defense that children were not targeted, and he repeated the fact that children were indeed killed and targeted, and this cannot be presumed to be regular, of course. So I heard Lian also made it clear earlier that the CLRV is really meant to be the voice of the victims, but Attorney Andres really took the opportunity to challenge the arguments that Duterte was not responsible. But still, the Attorney Andres still began and ended with the voices of the victim. The re-traumatization of the victims is really happening as we speak. Similarly to Lian, since I have been monitoring the pro and anti groups, I've also been seeing how tired the victims are feeling at this point. You can see it in their faces when they have to when they speak to the media. It's the tiresome is there, and even since I am following the pro Duterte groups, their vlogs have also come into my algorithm, and I've seen that the online harassment that has been targeting the drug war victims and their families. And so, according to Andres, he really ended with the point that confirming the charges against the former president would help reintegrate victims with their communities, where they have been very stigmatized, and that again, this would lead to the light and the truth of justice. John.
Thank you, Michelle. I'm just wondering, the pretrial chamber will decide in about 60 days. What's next for the victims? I mean, they're visibly worn, as you and Lian said, and they have 60 more days to know whether this will pay off in a decision to proceed with trial. What's next for them?
John, even if they are visibly worn, it doesn't actually mean that they're going to stop anytime soon. We did ask the same question to the Rise Up for Life and for Rights coalition, which held their regular press conference yesterday. And Attorney Chrissy Conti said that one of the next steps from this point is really the opening of the applications for more victims who want to participate. So if I'm not mistaken, there are over 500 victims that have applied or are expected to participate in the hearings in the next part. And so once the ICC is set to open these applications again, more victims are starting to realize that they can actually participate in this. Kasi may impression din kasi na kapag namatayan ka ng kaanak sa drug war, hindi ka victim. But then they're seeing that since they have also been affected, since they have also gone through trauma and loss, that they are indeed also indirect victims of this of Duterte's drug war, and they can indeed also still participate. And so those are also among the next steps, that they can also participate in the next parts of the hearing should the confirmation of charges continue.
I have a process question. The victims' counsel, how do they consult with the victims? Are they given like a room inside the ICC? How does it happen, away from the other parties?
To be honest with you, John, I'm not really privy to that sort of information of the exact process of how that happens. But at least if I'm going to speak about my personal observation, the human rights lawyers here, whether they are speaking in the ICC courtroom or whether they are just sitting with the victims in the public gallery, magkakilala naman sila. Yung mga nagsasalita sa courtroom, si Attorney Gilbert Andres at si Attorney Joel Butuyan, ay nakikita naman nila at nakakausap naman nila ang mga biktima na ito, and nakakamusta naman nila ang mga ito. It can be seen from the public point of view, but I'm sure there are also avenues na mas confidential as part of the ICC process.
Earlier, I asked Lian about foreign media interest in covering this historic case. I'd also like to know, are we aware of the foreign media interviewing the victims? I mean, and have we heard back from the victims? What kind of questions do they get from foreign correspondents?
To be honest, John, I have not personally witnessed an interview from the foreign media with the victims, but I do notice that the culture here is really that the foreign correspondents are also relying on the cues of the local Philippine media to really better understand the context and also help with facilitating questions and answers for the victims.
Do you need to talk to any lawyer before you can interview any of the victims, or if you know them well enough, you can just go straight to them and ask for their reactions?
It's more of the latter. And it's also more of how willing they are, you know. There are the two, for example, that we constantly speak to, which is Nanay Leore Pasco, who lost her two sons, or Shira Escudero, who lost her brother Ephraim. They are the ones who really are going out of their way, kahit napagod na sila, willing sila makipag-usap sa media about their experiences and tell their stories again and again. So it's also an individual discretion, but there might be some technicalities, especially pagdating sa mga, say, like, let's call them quote-unquote official victims of the ICC. Kasi alam natin na kaya nga sobrang daming redactions na nangyayari sa proceedings ng ICC kasi they also, as much as possible, want to protect their identities, especially those na hindi kasing tapang na lumaban in public.
So kaya ang pakiramdam ng mga victims, when the hearing resumes, we'll be hearing the closing statement of Kaufman, the defense counsel. I mean, I don't know if they're looking forward to being re-traumatized or ano kaya ang pakiramdam nila?
I can't speak for them, John, you know, but I feel that maybe yesterday might have been, you know, the worst part of it. Kasi buong araw na kay Attorney Kaufman yung floor. So whatever he might say today is something that they're probably expecting already.
Michelle Abad, correspondent covering the ICC, thank you very much. We'll see you again. We would like to thank Attorney R.P. Santiago of the Philippine Coalition for the ICC for his time and his insights. Thank you.
Thank you.
Before Rodrigo Duterte was arrested and detained in the ICC in March 2024, he was able to testify in the Philippine Senate, where he faced accusations of abuse during his bloody war on drugs. There, he said that he offers no apologies, no excuses. I did what I had to do. Whether you believe it or not, I did it for my country. Let us watch this clip from October 2024.
Before anything else, Senator, I'd like to thank the committee for inviting me para once and for all malaman natin ang totoo. So, I would like to request sa inyo na huwag ninyo akong ituring president or kaibigan. Treat me as a witness and tignan natin kung lalabas yung totoo. So, with your permission, at maraming salamat po sa inyong lahat for inviting me. I'd like to start my mandate as President of the Republic was to protect the country and the Filipino people. Do not question my policies because I offer no apologies, no excuses. I did what I had to do. And whether you believe it or not, I did it for my country. The war on illegal drugs is not about killing people. It is about protecting the innocent and the defenseless. The war on drugs is about the eradication of illegal substances such as shabu, cocaine, heroin, marijuana, party drugs, and the like, as a menace which ruins people, families, communities, and relationships, and tears apart the social fabric which binds society together in peace, harmony, and brotherhood. It is not unlike slogans which serve as calls for a better future, such as the war on waste, war on corruption, and war against climate change. I have always viewed people addicted to illegal drugs as victims and patients requiring medical help and not as criminals. That is why when the war on drugs slogan came into being, coined as first as a message to the people of Davao City to stay away from illegal drugs, but at the same time, I had a drug rehabilitation facility constructed in Davao City, a city government expense, manned by Davao City government doctors, psychiatrists, nurses, and health workers, among others, to look after the complete rehabilitation of those addicted to illegal drugs. I believe then and I still believe now that rehabilitation and not fear of death or incarceration to be the key to the return of the addicted individuals back to the mainstream of a just and forgiving society. But no mistake about it, I hate drugs. I loathe the purveyors, the merchants, and the pushers of this demonizing element. I have not failed to emphasize this from the very day of the campaign when I ran for the presidency in 2016. This was my covenant with the Filipinos who believed in me. And to this day, must still agree with what in government have achieved. It is unfortunate that drug-related crimes are on the rise again. Every day you can read about children being raped, people getting killed and robbed. And just recently, a drug den was raided within the Malacanang complex. This clearly manifests that the purveyors of this menace are back in business. Ano? Gawain natin. The Filipinos are anxious and distressed. Self-preservation is still the first law of nature. It is instinct. It is recognized in our laws as self-defense. That is why I have always told the police authorities and operatives to be mindful of this basic law of nature. However, I tell them not to abuse their authority and power, and hindi ko talaga pinayagan yung abuso ng pulis o sundalo kailanman sa buong buhay ko and as mayor for so many years and as president, in the guise of protecting themselves. But when your very life is placed at risk, and it can be snuffed out in a matter of seconds, then and only then must you act accordingly. Repel the aggression only in self-defense. Alam mo, matagal ako nagturo sa aming bayan sa Police Academy. When I was a prosecutor, to augment my income, noon na bago akong nagturo ako sa police. Ang sinabi ko talaga sa kanila, when you are arresting a criminal, you are not supposed to request him to surrender. Rather, you have to overcome the resistance. However, pag ayaw, it's the duty of the police is to overcome the resistance kung ayaw mag-surrender. At kung may baril, at kung tingin mo, sabi ko sa mga pulis doon sa academy, mamamatay ka, barilin mo. Barilin mo sa ulo. Patayin mo at least one less criminal in the community. Yun ang utos ko when I was a fiscal and I was a professor doon sa Police Academy. Yun ang turo ko sa kanila. No quarters given, no quarters asked. Criminal ito. Repel the aggression only in self-defense. Do not make orphans of your children and widows of your wives. I don't want that in my conscience as mayor and president. Hindi ko mabigat yan sa konsensya ko. I have warned. But before that, my job as president was never easy. And it was not meant to be. I have tried to do the best I can to address the problem of illegal drugs firmly and without compromise. for all of its successes and shortcomings, I, and I alone, take full legal responsibility sa lahat na nagawa ng mga pulis pursuant to my order. Ako ang managot. At ako ang makulong. Huwag yung pulis na sumunod sa order ko. Kawawa naman, nagtatrabaho lang. Yun ang gusto kong sabihin sa Pilipino at mabutit niyaya ninyo ako dito. Once and for all, yan ang gusto kong sabihin sa tao. I have warned all of you as your president then and as a private citizen now. Drugs will destroy the Filipino. It will destroy my country. And I will never allow it. Baski ako empleyado sa gobyerno o private citizen, I will do what is necessary to protect my country, my community, at yung mga anak natin. This is a matter of principle. At papagkamatayan ko yan. Maraming salamat. I'm ready to answer your question.
I'm telling the Filipino people, wag ako, it's gonna be bloody. I, Rodrigo Roa Duterte, do solemnly swear that I will faithfully, conscientiously fulfill my duties as President of the Philippines.
May operation, plantokan.
May trabaho ako. Pwede mo lumapit. Bakit hindi mo hindi?
Pagka bumunot, patayin mo. Pag hindi bumunot, patayin mo rin. Oh, tangin. Para matapos na.
Investigation shows that this wave of extrajudicial killings has been widespread, deliberate, and systematic, and therefore may amount to crimes against humanity.
Mga drug lords, drug pushers, they are not the humanity.
Yung isa pong police po naka po sa ulo ni Tian. Tapos yung isa po nakahawak sa ganito niya. Tinulak po si Kian sa gilid ng baboyan po. Tapos naririnig ko po si Kian na, "Sir, wag po, sir."
Pero shit happens. During operation, shit happens.
Local policemen of Manila are cleared of any criminal and administrative liability for detaining people in an inhuman secret cell discovered in April 2017.
Ayon sa CHR, 27,000 ang tinatansyang bilang ng pinatay sa ilalim ng war on drugs. Ayon sa pulisya, 7,884 ang napatay sa lehitimong operasyon. Ilan ang umabot sa Step 3 o yung mga nasa korte? 20 lamang. Wala pa sa 100 ang umabot sa Step 2 o yung hawak na ng mga prosecutor. Halos lahat ay nasa Step 1 pa lang. At pati ito ay kakarampot lang. Ilan ang kasong hindi naproseso ng justice system? Libo-libo.
Unfortunately, until now, the Supreme Court has not decided the case. There's no decision yet. But it has been like more than 5-6 years, no decision yet.
Ang sinabi ko ganito, prangkahan tayo, encourage the criminals to fight. Encourage them to draw their guns. Pagka lumaban, patayin ninyo para matapos na ang problema ko. I'm asking the ICC through you na pagpunta na sila dito bukas. Problem. Impossible dream. Okay na mga porado.
On 7 March 2025, Pre-Trial Chamber 1 concluded that there were reasonable grounds to believe that Mr. Duterte is criminally responsible as an alleged indirect co-perpetrator for the crime against humanity of murder.
I am Rodrigo Duterte.
5 taon na nakalipas. Kaya mo pang hintayin ang hustisya?
Kung mayroon pong hustisya, siguro po, ilalabang ko po.
Welcome back. You're watching Rappler's special coverage of former President Duterte's pre-trial hearing in the ICC. With me is Rappler Justice reporter Gyro Bolledo. Today is the last day, and earlier we heard the closing statements of the prosecution and the victims' counsel. We are waiting for the live stream to hear the closing statement of the defense. Jairo, what do you think Kaufman will say?
Likely he will, close his statement by highlighting again why the supposed acts of the former president, do not constitute crimes against humanity. That's one. Maybe he will, take a swipe again at the victims and downplay the killings once more. And of course, he will highlight also, maybe he will also respond to the direct replies made by the prosecution. As we've seen, itong prosecution and the victims, they dedicated their closing statements, basically refuting what Kaufman said in the last, yesterday and today. So maybe Kaufman would try to do the same. And after all, they have the last say here. Basically, they're the defense. They enjoy that right to have the last say.
I can't help but remember what Julian Nichols said at the start of the closing statement of the prosecution. He also took a swipe at Kaufman.
Yeah.
Kaufman was saying, like, how can you believe a criminal? How can you put stock in his testimony? And then Julian Nichols talked about, he is quoting this document saying, or this person, that there is no sinister meaning to neutralization, but that person happens to be Bato de la Rosa.
Yeah.
Right?
Basically, he's mentioning na parang hindi wala naman daw ganun, but it's the same man that we're talking about. That man is actually Senator Bato de la Rosa, who signed the PNP Memorandum number 16, series of 2016.
The closing statement actually isn't the last thing that will happen today.
Yeah.
There's another. Actually, it's another hearing on the detention. Can you very quickly just walk us through that?
Yeah, under the ICC rules kasi, the ICC chamber handling the case or the ICC itself is required to review the detention of a person every year. So in this case, for 2020, basically for this year, 2026, the ICC Pretrial Chamber 1, which handles the 3 cases of former President Duterte, is required to hold another hearing to check whether detention is still suitable for the former president. Under the ICC rules kasi they are bound by the rules to check whether yung detention na yon, kung saan man siya nakakulong, ay suitable pa rin sa conditions.
So it's a periodic review?
Periodic review, yes. Every year.
And the decision whether to let him stay or to move him somewhere is taken today?
Not
necessarily.
We're not really sure, but if we're gonna look at the communication provided by the pretrial chamber, they said that their decision could be released within 60 days. So we're not sure if kasama dun yun, it would be a different resolution, but likely it would be because yung 60-day that they're referring to doon ay doon sa confirmation of charges. So they will have another document on their decision on the interim release.
So after this very intense week, we have to wait
another
at least 60 days before the court decides.
And another thing that Attorney RP said a while ago, yung 60 days ay minimum. So it could be longer. So probably 2 to 3 months. Kasi if we're gonna look at the interim release, yung lumabas yung decision on the interim release last year, hindi siya instant agad diba? Parang a few months. It took a few months before the pretrial chamber issued its decision on the interim release or on whether, release the president on provisional grounds.
Michelle Abad did say this earlier when we talked to her, that it was yesterday that was traumatic for the victims, because the entire day yesterday was reserved for the defense. But even then, I would still think that they're not exactly looking forward to the closing statement of the defense kasi meron siyang asta, parang meron siyang mga pitik na may sinasabi siyang parang sarcastic tungkol kay Butuyan, and then hindi naman siya ganun dun kay Nichols. They call each other my friend and so on because they've been arguing against each other and I guess together. Pero yun nga, when you think about this victim-centric judicial process, you can't help but think of the victims, no? I mean, so now they're going to hear the defense counsel try to close their entire argument.
Yeah. And another thing on the victims, John, nabanggit din kanina ni Attorney RP when we're having our dinner during the break na it's important also to highlight in these ICC proceedings that these proceedings are not only meant to seek justice from Duterte himself, but also to, have a reverse concept of reverse complementarity. Maganda yung point na yun ni Attorney RP Santiago. Kasi di ba supposedly, the ICC took jurisdiction over this case because there was no complementarity. Under the Rome Statute kasi, di ba, the complementarity means a member state is willing and is able to investigate its own crime. Kasi kung hindi, doon papasa yung ICC. In this case, in Duterte's case, the ICC Office of the Prosecutor in the pre-trial chamber, the appeals chamber rather, was, they were convinced that the Duterte administration wasn't able to do a genuine investigation. It basically failed to investigate the crimes committed under the war on drugs. That's why it took over. Now, yung reverse complementarity na sinasabi ni Attorney RP, now that we're here, this should serve, as a lesson to the Philippine local justice system, to our local justice system, na para maiwasan natin in the future. Kung ayaw natin ng ganitong ICC proceedings, ayusin natin yung local justice system natin. In that way din daw kasi ma-assure natin at ma-ensure natin na mabibigyan lahat ng justice. Kasi tama nga naman yun. Dumadaan ng rigorous process bago ka ma-accept as, authenticated victim in this war crime. So, sana yung mga walang kakayahan or hindi nakasama dito sa bilang na ito, mabigyan din sila ng justice locally by fixing our local justice system. And it's not too late for the Marcos administration to do that. It can strengthen, the local justice system by ensuring that prosecutors are independent, by ensuring that the judges he appoints are independent, but also by rejoining the ICC to, to have a deterrent against future abuses. Now that we're talking about the 2028, 2032, 2036 rather, and the other upcoming presidencies that we will have in this country.
I want to talk about that, no? Yung returning to the ICC. I realize in the end it's a political decision, right? Yes. But is there anything over the last 4 days that can serve as a good argument, no? Nabanggit mo nga yung deterrent, that will convince all parties na it's better to be part of the ICC rather than to be outside it?
It's always, better to be part of the ICC kasi it's an assurance that there will be, a concept of justice for everyone regardless of the administration. Although the motivation could be and would be political for Marcos, speaking about Marcos, the implications would be on the, the grander scheme of things, di ba? Para in the future, kung ayaw natin ng ganito, in the future, kung magkakaroon naman ng abuses from the part of our president, from the part of, top military officials or whoever, merong ICC na nakaabang dyan. But then again, katulad ng argument na maraming lawyers, strengthen din natin yung local justice system din natin. That's actually better if we can, seek justice and accountability from our local soil. But then again, if that's not happening, and if that's not, an available option for us, then we have the ICC. But so it's better if we join the ICC, but at the same time, have a local and more stronger local justice system that really works.
Monday seems like a long time ago.
Yes.
But last Monday, we did talk about this, and you did criticize President Marcos for not returning to the ICC. Anong usap-usapan sa mga justice beat? What's holding him back?
Really, we don't know. As in, we don't have any idea why Marcos won't join the International Criminal Court. During the early years, during the early years of his presidency, we understand that there's no sense of urgency for him, especially that, he still enjoys his, still in alliance with Duterte. But then again, everything changed when, Marcos and Duterte had this rift. Duterte was sent to The Hague. So we were kind of expecting that, the Marcos administration would probably go to that direction of rejoining the ICC. But then again, Wala eh. Wala akong personally on my knowledge, even on insider information, talking to sources. I don't have any information of, the president talking about supposed rejoining. What I know is that the Marcos administration, at least for the part of the former ombudsman Boying Remulla, is willing to reinvestigate the drug war. But that's the closest thing to drug war accountability as far as this administration is concerned. But then again, looking into how Marcos really operates his administration, it could probably be a good, what do we call this? It could be probably a good move or a political move for Marcos in the coming years, especially toward the end of his presidency. Remember, we're at the tail end of his administration. At ito na yung legacy building na tinatawag in these cases. So probably in those years, kung gusto ni Marcos talaga na magkaroon ng legacy building, he would investigate these drug war killings. And at the same time, maybe that's why, baka sumali siya sa ICC again. We don't know. But pwede niya kasing gamitin yung joining the ICC as a political leverage, especially in the upcoming elections, 2028.
Pero posible rin na
hindi.
No, that he might be afraid that it will work against him.
Yeah, that's the problem with the Marcos administration. It's, dilly-dallying all the time, wishy-washy on their decisions. Tulad nito, yung ICC, John. For example, nakakagulat talaga for me and Lian, na napadala talaga si Duterte on last March 11 last year because as we've been covering the Duterte and the Marcos administration on the justice aspect of it, and then lagi naming ninonote kung willing bang makipag-cooperate yung Marcos. If we're gonna look at the history of how Marcos administration look into the ICC, hindi sila willing makipag-cooperate. Lagi nilang sinasabi, the Philippines won't rejoin, hindi sila makikipag-cooperate and all that. Then nagulat kami, come August 2024, nagkaroon ng change in tune. As in, out of the blue, this Justice Secretary Remulla is saying na Interpol is another option for the ICC, for the Philippines to cooperate with the ICC.
Thank you, Jairo. Now, the live stream resumes. It's time to listen to the closing statement of the defense.
Please be seated. Veuillez vous asseoir.
Judge Motor. Good afternoon, everyone, once again. Mr. Kaufman, you have the floor for 30 minutes for your final submissions. Please proceed.
Thank you, Madam President. Thank you, Your Honours. I don't propose to present a long rebuttal. The defence has made its submissions comprehensively, and it stands by everything that it has said and presented. I am, however, forced to respond just to a couple of the most egregious observations made by the learned prosecutor and the learned victim's representative. I will start with Mr. Nichols, the prosecutor, who tried to convince you that I had admitted that you cannot trust anything coming out of Mr. Duterte's mouth. Well, he took it completely out of context, didn't he? What I was saying, and what everybody understood, is that Mr. Duterte's speeches alone are totally insufficient to substantiate the charges against him. And the learned prosecutor apparently agrees. He said, throw them all out for the purpose of the confirmation. Even without the speeches, we have enough to confirm the charges. And then he celebrated the fact that he had managed to find one, and I stress, just one, example of a direct order, so he thought, to kill, emanating from Mr. Duterte, and that is to be found in Incident 1. So, for the benefit of the record, let me just clarify and repeat what I said, and I refer you to transcript 4, page 65, at line 14 onwards, and I quote, P26, who, redacted, claims that Mr. Duterte telephoned a redacted third party to order the operation and was told it was the mayor on the phone. Hyphen pure hearsay. That's what I said during the hearing. And I stand by my word. But because I thought that maybe Mr. Nichols might have caught me out, I went back to the transcript and the record, and I looked long and hard, and once again I quote P26's words from the evidence. I asked who called, and the redacted third party said, Superman. And to make things clear, the prosecutor's investigator then asked P26, was the person who took the call? Was it the redacted third party? And the answer he received was yes. So I repeat my submission with even more emphasis. Pure, unadulterated, and undiluted hearsay. What Mr. Nichols' rebuttal boils down to, maybe he didn't mean to infer it, but he did, all it boils down to is a plea that, well, Kaufman's pointed out a few problems, let's just leave it for the trial judges to sort out. And for that, he's quite happy to let Mr. Duterte fester in detention for years to come. In the United States, they call that kicking the can down the road. And as for the learned victims representative, I've been restrained up until now. I've paid my respect to the families of those who have lost loved ones, and I repeat that expression of sympathy that I made as my very first statement on behalf of the defense. But I would like to remind the learned representative for the victims that he is not a mini prosecutor, and to regale the pre-trial chamber with unsupported allegations that many, many children lost their lives is utterly inappropriate. His stance and that of his colleague have reflected the media reporting of this case, namely complete disregard of the evidence, and to be frank, you haven't heard one single piece of evidence cited by them. That's why they have Ms. Massiter sitting next to them. Indeed, the media interest in this case has been intense, but it has followed a familiar theme. Rodrigo Duterte is finally behind bars where he belongs. And as a defense lawyer, I stand up and I talk about due process, fair trial rights, and the presumption of innocence. But what use is that when the whole world has already tried and convicted him, and furthermore, make emotional arguments to justify their position? What about the presumption of innocence? Mr. Butuyan talks about threats emanating from mini Dutertes. He says that people are threatened by Duterte clones in countries all around the world. He tells you about Rodrigo Duterte converting millions of peace-loving citizens into bloodthirsty disciples. Not dozens, not hundreds, but millions, so Mr. Butuyan says. What an insult to the Filipino nation. And Mr. Butuyan concludes by presenting an emotional ultimatum. Confirm or Duterte will be portrayed as the person who vanquished the ICC. Those were his words. These submissions were quite unique for this court, and of course, totally irrelevant for the purpose for which we are gathered here today. And as for the mainstream media, back in the Philippines, the situation is not much better. When I argued that there has been interference in this case at the highest level, relying not on documentation that I have invented, but on documentation given to me by the prosecution as exonerating, they say I'm making a political speech and that my defense lacks substance. And when I devote more time than the prosecution and the victims together to legal arguments and challenging the evidence, they say I'm nitpicking. Well, fortunately, we have this honourable bench which appreciates the presumption of innocence and the need to examine the evidence thoroughly in order to examine whether the prosecution has proved its case to the required standard. We are fortunate in that we have this honourable bench to review the various arguments dispassionately and professionally. And we know that this honourable bench, despite our struggling with the various redactions that have considerably reduced our ability to make comprehensive submissions in open session, we know that this bench will assess our arguments faithfully. We have provided a comprehensive analysis of both the law and the charged incidents. We have attacked every single count in open session while doing our very best to respect the restrictions imposed upon us. and applied by the prosecution to its charging document and pre-confirmation brief. And these redactions have not just been a few here and there, they have been so sweeping that virtually nothing intelligible remains of the 49 incidents that we have been talking about for the public to read and to understand. Let me just screen you an example from the public record, from the public version of the pre-confirmation brief, so that the whole world can appreciate it. And the same goes for the redactions applied to the identities and roles of the various criminal cooperating participants. While I found this unfair and contrary to the spirit of transparency, which is meant to govern the conduct of the proceedings at this institution, I approached my counterpart in the prosecution and complained that the nature of his redactions would mean that most of my meaningful submissions, namely the attack on the evidence substantiating the 78 deaths, would require me to go into closed session. Don't worry, I was told by the learned prosecutor. We're going to release a lesser redacted version of our charging document and confirmation brief. Wonderful, I said to myself. But what in due course did we get? A document which merely released the names of the 8 so-called co-perpetrators and which caused a storm in the Philippines. It even caused the Secretary of the Interior to state that his department had begun tracing the whereabouts of these so-called co-perpetrators. And in its lesser redacted version of the document containing the charges and pre-confirmation brief, the prosecution also released the names of certain high-profile victims which it had selected, thereby enabling it, and it alone, to talk freely in open session about certain incidents that it felt crucial to its case. From this, I submit, Your Honours, you can really appreciate the true inequality of arms facing the defence as it attempts to defend a client in the public eye, I stress in the public eye, at the International Criminal Court. This inequality of arms in the public eye expresses itself in the way the prosecution controls the narrative by arbitrarily lifting redactions so that it can make its narrative of a grand scheme of co-perpetration known to the public in open court, while the defence can only meaningfully attack the real meat and the substance of the charges, either obliquely or in closed session, including that hotly disputed incident with the CCTV. Well, we hope that we have found a way around that by referring Your Honours to the relevant places in the evidence, and we do trust you to pick up on the problems without the benefit of our full explanations in open session, even if the remaining part of our plea was rendered rather dry. But I do assure you, the general weaknesses that we have identified pervade throughout and are so recurring that the total value of the prosecution's evidentiary matrix drops not just below the substantial grounds threshold that the prosecution must meet, but hits the very rock-hard bottom. And I will summarize these weaknesses once more for the record. Layered hearsay, conjecture, over-reliance on accomplice evidence with offers of virtual immunity at the ICC, contradicting statements between participants in a crime, absolute lack of any linkage whatsoever to Mr. Rodrigo Duterte, and the total lack of support for an alleged crime both in the documentary and forensic record. And regarding these documents, it is not enough to argue that the Duterte administration destroyed them. There is absolutely no evidence for that. It is an outrageously unsubstantiated accusation which is not alleged, and where the documentation does exist, the prosecution is quite happy to rely on it. But what is this threshold, this substantial grounds to believe threshold? Well, clearly, it is not beyond a reasonable doubt. That's the standard required for a conviction at trial. But it is considerably more than reasonable grounds to believe, which is the standard applied for the issuance of an arrest warrant. If I may, let us take the analogy introduced by Mr. Butuyan, that boat of his that set sail in order to avoid leaving his victims stranded on an island. Your Honours, this boat is the confirmation process, and its captain is this honourable bench. We are all passengers in this boat. The favourable winds in the sea and in the sails are for the prosecution, the incriminating evidence, and the sharks and the rocks in shallow waters are the exonerating evidence, the hearsay, the contradictions, and the accomplice witnesses. I ask you to consider how many sharks and rocks that we have discovered and pointed out to you through our binoculars. Would you board that boat if you knew that there were substantial grounds to believe that the boat would sink if it encountered one of the aforementioned perils? Let me define the test using more strictly legal language. The evidentiary standard applicable, namely substantial grounds to believe, is met with respect to a discrete incident when, and I quote from paragraph 38 of the Said confirmation decision, there exists concrete and tangible proof demonstrating a clear line of reasoning underpinning the specific allegations. By way of parenthesis, I should state that this quote from the Said confirmation decision recognizes the fact that each pleaded incident in a document containing the charges must be proved to the requisite standard for it to be adduced at trial. And that is what we request the Honourable Pre-Trial Chamber to consider. I have been asked by the many journalists who literally mobbed me outside this court building whether I have been reporting on the proceedings to the former president. And I tell them, yes, of course, that's my duty as a lawyer. I have to report to my client. It would be unethical otherwise. And they ask me, what has he to say about the case? Well, I'm going to enlighten you all a bit. For the best part of a year, we have been litigating the issue of jurisdiction and fitness. Your Honours have delivered your rulings. However, even though you found him capable of standing trial, I permit myself to tell you just a little bit about what really goes on in prison. No more than a kilometre from here. I permit myself first to tell you about his reaction to the demand of the prosecution and the victims that he appear. I won't hide the fact that I thought it best for him to appear, not out of a need to satisfy the desire of the prosecutor and the victims who desperately want him to face his accusers so that they can wave their collected finger at him despite the presumption of innocence. I did not want to disappoint his many supporters. That was my reasoning. Those mini Duterte clones, as Mr. Butuyan derisively calls them, who have been deprived of seeing their former and beloved president for more than a year. I told him that Your Honours could have rejected his request to waive the right of attendance. We even had a barong specially fitted for him so that he would not have to suffer the humiliation of being put into an out-of-size blue suit which would now dwarf his meagre physical body. The same blue suit in that dreadful photograph which still remains on the ICC website and that I would ask to be removed. But he took his decision, and as his counsel, I was obliged to respect it. And the day before yesterday, when Your Honours gave us a break, I went to that prison and I sat with him for an hour. I tried to engage him concerning the evidence, and he lost the desire to follow me within less than a minute. I offered to show him excerpts of the confirmation proceedings, a few minutes of the deputy prosecutor, a few moments of Ms. Massiter, and hoping that it might excite him a bit more, some of my own opening statement. He shook his head firmly. I implored him. I said, "Sir, look at what we are doing for you. We're doing our utmost to get you out of here." But once again, he politely declined. And I asked him why. I said to him, "Sir, don't you understand? They accuse you of murder. They say that you murdered thousands when you were the mayor and when you were ruling your country." And then he repeated the question that he has always asked me for a year or more. "How does the prosecution say that I did this?" "Well," I replied, I thought until Monday that it was because of those speeches of yours. But then your prosecutor told the honourable judges the other day, throw them all out. They're not necessary for the confirmation. He claims that he still has enough evidence to convict you without all the bluster. And the former president repeated the question, but how? I've never murdered anyone. And they talk about thousands. And then I tried to explain to him arcane concepts such as indirect co-perpetration. And then his eyes simply glazed over. And who can blame him? As I mentioned, it is the only highly technical means whereby the prosecution can artificially connect him to criminal activity not of his own doing. I then tell him that the people who are incriminating him are self-confessed murderers cooperating with the prosecution, whose names we can't mention in public. I tell him that in return for their dubious services and their expressions of so-called remorse, as the prosecutor puts it, they will not face trial at the ICC, probably nowhere in the world, and will be rehoused with new identities. Mr. Duterte, the ex-prosecutor, like me, can't understand the fairness of that, relying on not one, but a number of vicious criminals to convict him, when he remembers that he is supposed to be presumed innocent. I tell him the names of those criminal cooperating witnesses, because apart from us, he is the only person who is entitled to know. He tells me that he has not heard of any of them, apart from two, who he vaguely recalls from his days as mayor. Concerning one, his comment is liar, and concerning the other, scallywag. And then, exactly in the spirit of the waiver filed with this court, he looked at me solemnly and said, Mr. Kaufman, Nick, I have done my duty and I have left my legacy. Go to court and do your job, but I can no longer help you. I no longer remember much at all, and I can't comment on people who I do not know and on statistics that mean nothing to me. He then concluded and pronounced as follows, I was a faithful servant of the people, and that is how I wish to be remembered. I have now accepted my fate, and I realize that I could die in prison. And on that somber note, my team and I realized that there was no point in continuing. So we tried to humor him. We told him that next month he will be 81. And we reminded him of the many people who visit Duterte Street and Duterte Park, the renamed locality just outside the ICC detention center, as referred to by the many, many pilgrims who have visited The Hague to feel closeness to his presence, even if they cannot witness his actual person with their own eyes. We remind him of the mountain of cards and greetings and of the forest of flowers that he received both at the detention center and at the court's premises on his 80th birthday. So many cards, all of which were read by his family, that we had to provide 2 sacks to take them back to our office. So many bouquets of flowers that the prison had to bring a van to take them away. The flowers that reached the court premises were strategically placed around the building, and although so appealing and desirable and coveted by the staff, were avoided once the staff was told of their origin. So these flowers just rotted in the corridors until the smell forced them to be thrown away. We showed him some photographs of his family. We showed him photographs of his youngest daughter, Veronica, Kitty, who writes to him every day so often that the letters are piling up in his room. His face starts to light up. We showed him pictures of civic events in the Philippines with Sebastian Baste and Paolo Pulong present. He laughed and told us what he remembers of their days as young men in Davao. We showed him pictures of Inday Sara greeting the enthusiastic crowds of people in the Philippines, and then finally his face beamed with pride. Your Honours, it is so easy to choose as a target for prosecution a politician because of the way he presents his policies. If Rodrigo Duterte is to be faulted for anything, It is for his inappropriate choice of language. But he murdered no one. Out of that huge database of evidence on which the prosecution relies, I repeat that there is absolutely nothing to directly link Rodrigo Duterte to the 78 deaths alleged. That is why they rely on a few selective and vociferous individuals in the Duterte administration, calling them co-perpetrators, just so it can artificially superimpose their fantasy common plan theory linking Rodrigo Duterte to the victims. Your Honours, I beg you to be guided by evidence, which must reach a minimal level of integrity. Be persuaded by your own innate sense of justice and by your own collective years of experience. But most importantly, be guided by coherent evidence and by common sense. I ask you, I beg you not to confirm any of the charges. I ask you to let Rodrigo Duterte return to the Philippines, not to govern, but simply to let him live out the rest of his days in peace, in his humble dwelling in Davao. And with that, Your Honours, I conclude, and I wish to thank you for your patience, and to thank the parties and the participants, and most importantly, my team, Dov Jacobs, Havnit Nikisetti, Sandrine De Sena, Davide Rancati, Alexandra Dezev Davi, Nicholas Russo, and Kaylin Chen, all of whom have worked throughout the last year for one cause alone, and that is to serve our client, Mr. Rodrigo Duterte, faithfully.
Merci beaucoup.
Judge Motok, thank you very much, Mr. Kaufman. The Chamber, my colleagues and myself, we have the duty to recall certain issues. First of all, the reductions that you have mentioned now, it was already raised by the defense, and the chamber had taken a decision rejecting the position of the defense. The number of the decision is 388. And I should say that the quality of arms is ensured because the defense has access to the redacted information. It just is not available to the public. Secondly, you talked about the health and capacity of the suspect. As you have clarified, this issue was already addressed by the chamber, and the defense must not make submissions on that point now because it is not appropriate. The decision is already available in the public domain. I thank you very much, and with that we come to the end of the confirmation of charges hearings. I thank the parties. Did you want the floor, Mr. Prosecutor?
Yes, whenever is convenient for you, Your Honor. Yeah, thank you, Your Honor. I don't want to stand up and object to my friend, but I would request and ask that you strike and not take any account of any word that my friend said came from his client. None of that was responsive to arguments, which is what these last 30 minutes were about. You made that clear on pages 24 and 25 of the transcript today, and it's in paragraph 9 of your order on the conduct of the hearings. Second of all, my friend can't testify for his client or make a speech for his client. That's governed by Article 67H. If he wanted to come here, he didn't want to come here, he could have come here and talked about whatever he wanted to, but he chose not to. Mr. Kaufman's conveying this. He's been complaining about hearsay all day. It's not reliable, but beyond that, if Mr. Duterte wants to speak to the court and speak to the gallery, he should come here, request to make an unsworn statement. He shouldn't do that through his counsel. So I ask that all of that be given zero weight whatsoever in your determinations. Thank you.
Thank you, Mr. Prosecutor. You want the floor again, Mr. Kaufman?
Madam President, but I do believe that the defense has the right to respond.
Wait.
Yes, says Judge Moto.
And I say to Mr. Nichols that this was not testimony. It was purely an explanation for him not coming to the hearing. He has the maximum respect obviously, for your honours. But he has his arguments, which we shan't repeat here once again. They were all set out in the waiver. That was not testimony, I assure you, Mr. Nichols.
Merci. Judge Murdoch, thank you very much. Now the bench will withdraw to deliberate, and we will render a decision on the confirmation of hearings within 60 days in accordance with the instruments, the provisions. We will come back to this court for a hearing on Mr. Duterte's detention. Court is suspended.
Welcome back. We just heard the closing statement of the defense, followed by a skirmish, which we did not expect, between the prosecutor's party and the defense, which ended with the presiding judge saying they will withdraw and render a decision in 60 days. Gyro, I know that the next step is they will come back to proceed with a hearing on the detention, right?
On the detention.
But I thought that it would seamlessly move on to the to this second hearing, but I think we need to wait for indication from the court, from the ICC.
If they would really, stream it like the confirmation of charges. Because before they cut off the stream, they said that the chamber was in closed session, private session.
What struck you with the closing statement of the defense?
Not necessarily, I don't think struck the word. Struck is the word, but more of like fascinated. I don't think in a good way. It's the supposed conversation between Kaufman and Duterte. Kaufman said he was able to talk to the president while in detention, but we're gonna look at the messaging, the rhetoric of the supposed conversation. We all know that Duterte doesn't speak that way, especially when he said what really, bothered me was a direct quote, supposedly from Duterte, as quoted by Kaufman. Duterte said, allegedly, that he told Kaufman that he never murdered anyone, and they talk about thousands, but we're pretty sure that we have, tons and lists of, a list of articles and stories quoting Duterte admitting to killings. I was looking at 2015 article in December 2015. Duterte, in fact, boasted about the supposed killings in his hometown. This was also cited by the prosecution. Duterte in 2015, he was asked about the supposed killings in Davao, about 100, 700 to be specific. And then Duterte replied, boastingly, he said, no, make that 1,700. And among other admissions, the 2024 admissions, the past admissions, it's really, really weird for Kaufman to go to that route, especially that in his presentation on the merits, he did not really dwell much on the rhetoric, but more on the supposed contextual meaning of those statements rather than the rhetorics behind it. But in this case, in his closing, he parang nag-rhetorical style siya. And then it's really interesting that, he supposedly highlighted the conversation about him and Duterte, about the photographs of Duterte's children, Kitty, Sarah, when in fact, we all know that the Duterte family has their own factions within them. And it's really interesting that, Kaufman is making it appear that the Duterte family is one big happy family, that, the Dutertes are really intact, while in fact, it's not. If we're going to look at the Supreme Court petitions, why would Duterte's children have separate petitions if they are really in consonance and unity in defending their father? And really, the handful... For example, this one. I no longer remember much at all. as far as we...
I mean, that's convenient for their case.
Yeah, diba? Because they're arguing that Duterte has short-term memory, that Duterte can no longer, cannot remember much of the details because they're trying to play this, Duterte is no longer capable to mentally understand the proceedings and all that. But as you can see, the chamber is not really, pleased with this, especially when they decided on the petition, finding that Duterte is actually fit for trial. So, yun yung mga observations ko on my part.
What struck me was that earlier, in trying to rebut the prosecution's submission regarding count 3, Kaufman said, this requires proof, not emotion. And yet, in his closing statement, the second half is a pure appeal to emotion.
A pure appeal to Duterte supporters.
Yeah, I mean, painting this portrait of a man who was not that interested in, it sounds like, it seems like a scene from a movie. Diba? So what I got there was that he was playing victim's counsel. And his essential argument is that the real victim here is Duterte. Look at this guy, he only wanted to do right by his people and they're putting him here. And I mean, that's really part of the playbook as well. Right? So I was a little surprised that he ended that way. He did say something about the reductions and also the Judge Motok actually did say that don't bring this up anymore. It's no longer an issue. It's already been decided.
Yes.
Right?
Yes.
So he was saying, how can it be fair? He was talking about inequality of arms because they didn't have the same access to the data. And the judge said, that's already been decided. There is equality of arms. Then the judge also said, I found it very interesting, the judge starting by saying, we have the duty to raise some concerns in relation to what you just said. No? So the only kind of reaction to a closing statement. The other thing that the judge said was that this painting, you're painting a portrait of a weak and diminished Duterte. She said, health and capacity of the suspect, that's already been addressed by the chamber. Essentially scolding Kaufman, you must not make submissions on that part now.
Yeah.
Settled na.
Yeah, it's very important to note that kasi it's part of their disinformation network kasi their disinformation campaign that apart from really, addressing the supposed legal points pending in resolution before the chambers, they're really trying to win the emotional war or the emotional part of these ICC proceedings by highlighting how Duterte is supposedly frail and old. Sabi niya pa nga, di ba, may barong na daw, ready na daw sila, pero hindi na daw kasya yung suit and tie. But then again, why didn't they appear? I mean, bakit hindi nila hinayaan na mag-appear si Duterte when in fact, kung kawawa naman talaga siya, bakit hindi na ipakita? Because hindi yun convenient at hindi yun mag-fit dun sa kanilang narrative na kawawa si Duterte because people will judge by themselves whether Duterte is really that frail and old. And as far as we are concerned, as far as, the ICC facilities are concerned, I don't think the ICC is really, letting Duterte, be on that stage. Katulad nung sinabi ni Judge Raul Pangalangan noong 2025 after Duterte's arrest, we asked Judge Pangalangan, kamusta po yung facilities doon sa Cheveninian prison, doon sa detention facility ni Duterte. Ang sabi ni Judge Pangalangan, actually very, very suitable yun for persons deprived of liberty. Maganda yung facilities, maayos, meron silang maayos yung mga health facilities. Could be better than the Philippines actually. So I don't know where Kaufman is coming from in highlighting those. That's why tama yung ginawa ni Judge Motok to highlight that na hindi na to relevant sa proceedings. We're talking about the merits here. That's the point of the judge. We're talking about the merits. Do not question or do not raise points about the health status of the president, the mental capacity of the president. We are talking about the merits or the evidence again on the allegations.
I remember that Bongo said in the early days of Duterte's detention, so about a year ago, hindi daw binibigay ang maintenance meds ni President Duterte. No? I mean, this is a high-profile facility. Everybody's monitoring what happens there. It seems like a stretch. Interestingly, ito yung skirmish na that we mentioned, no? Interestingly, Mr. Nichols stood up for the prosecution and said, I request that last half of his closing statement be stricken off the record, no? Because, as you said, no, if he wanted to testify, he should have come here. You cannot testify on behalf of your client.
Yes, exactly.
And I think that was a very good point because that forced Kaufman to stand up and say, Your Honor, this is not a testimony. It's only, what did he say?
An excerpt.
A pure explanation of why he is not here. Which is, just another way of saying, I'm testifying on behalf of the client.
Yeah, if they're really going on that route na kawawa naman si Duterte, matanda na siya, the confirmation of charges was really their problem because kapag na-confirm itong charges at umakyat tayo sa trial, wala lang choice si Duterte not to appear. Hindi na siya pwedeng mag-waive ng appearance. That's their problem. Kapag pag ang ano lang nila, ang goal lang talaga nila dito ay mag-feed dun sa kawawa narrative, and then people will see in the trial na ay, di naman pala siya payat, maayos naman pala yung kalagayan niya, inaalagaan naman pala siya ng ICC. Then they will lose at least an aspect of their on their emotional war against this ICC proceedings. At that's the challenge for them, lalo na if we're gonna look at it. And likely, according to our experts, substantial grounds is basically mababa na threshold or requirement. And looking at the evidence so far presented, ay malaki yung chance talaga na ito ay mako-confirm, lalo na substantial grounds lang naman. Sabi nga kanina ni Attorney RP, off record, kasi natanong ko siya, very, very unique nga kasi po yung, di ba, yung proceedings ng ICC. So yung dito requirement kasi para umakyat, probable cause, para umakyat ka dun sa court natin, dun sa hearing. This is not even probable cause nga daw yung substantial grounds to believe, according to many lawyers. So if we're gonna look at that, threshold, possibly.
Si Kaufman naman, he did say that we need to have more than reasonable grounds, but below beyond the reasonable doubt. No? So yung parang he was making this, drawing this spectrum. So yung substantial grounds, sabi niya, is higher than reasonable grounds, which I would think is like probable cause, no, to have someone arrested, but lower than reasonable standards. So he was appealing to the court na I hope you realize that hindi nga siya substantial grounds. No? Yung pinaka-argument nila, he went through it very quickly. No? Sabi niya, ano nga yung mga sinabi niya? No? It's a conjecture, ito pa ulit-ulit niya, yung virtual immunity. I think nasagot na to ni Nichols na itong mga prosecution witnesses who were part of the criminal enterprise were not promised immunity, right? And even if you say virtual immunity, that doesn't make it real. No? Pero inulit niya, ulit din sa closing statement niya. No? So yan, dinaanan niya, puro conjecture lang to, this fantasy, contradicting statements, absolute lack of, total lack of support. Do you think that was enough to sow the seeds of doubt sa mga judges?
The problem there, tama naman yung technique as the defense. Really, the job of the defense is to create doubts on the evidence provided by the prosecution. The burden of proof in criminal proceedings, the burden of proof lies on the prosecution, and in this case, the burden of proof lies on the part of the prosecution. Nichols, Jeremy, dito kaila Robin Croft, etc., etc. But looking at that, the problem with Kaufman's arguments kasi they did not really, directly answer the allegations, and he's making it appear, he's also making an appeal on the supposed presumption of innocence to Duterte, which is misplaced at this point in time, because if we're going to talk about presumption of innocence, let us clarify that Duterte still actually enjoys presumption of innocence. That's why actually we're having this confirmation of charges. I don't really know where it's coming from. actually, this confirmation of charges actually provides another layer for the supposed suspects, for the soon-to-be accused, to have another layer of protection to ensure that he's not really, he actually enjoys presumption of innocence. And that's really misplaced. That's really a misplaced argument from the part of Mr. Kaufman.
Dalawang levels nga di
Yeah.
ba? Before he could be arrested and now before the trial can proceed, he's given this opportunity.
Exactly. So we have the preliminary examination, and then we have the investigation of the prosecutor. And now we are on the pre-trial sa Pilipinas nga. 'Di ba? After ng resolution ng prosecutor, nakakita ng certainty of conviction, probable cause with a certainty of conviction ng prosecutor sa Pilipinas, it will file a charge or information in the court. And if the court finds probable cause to issue a warrant, arrestuhin ka na agad. Then you go agad to trial. Dito nga may pre-trial pa nga. Kaya sobrang daming, kumbaga, compared to the Philippine jurisdiction and other jurisdiction, this ICC is actually, provides a lot of avenues for Duterte, in fact, to enjoy presumption of innocence.
Yung, is that not yet, no? So again, we're waiting for the ICC. Okay, all right. So we will be
in the online news portal of.
Can the French booth please turn on the microphone? Thank you.
The news source about this action of Mr. Duterte's children is found in online news portal GMA News Online, and the news article is entitled, quote, Duterte Kids Tell S Supreme Court Petition for Father's ICC Release Not Moot, unquote, dated 6 January 2026. We will forego arguing the statutory basis of our position and contentions, Your Honor. Thank you, Your Honor.
Judge Matak.
May I continue, Your Honor, because there was a misunderstanding on the...
Oui, vous pouvez continuer.
Yes, please proceed.
We further wish to point out, Your Honors, that the conditions set forth in Article 58, subparagraph 1 of the Rome Statute continue to be met, and there has been no change of circumstances within the meaning of Article 60, subparagraph 3 of the statute, or Rule 118, subparagraph 2 of the Rules of Procedure and Evidence that would support and justify Mr. Duterte's release from detention. On the contrary, as we have shown earlier, the new developments support his continued detention. In fact, we wish to emphasize that the prior findings that supported Mr. Duterte's continued detention remain valid and undisturbed, particularly in light of the fact that the confirmation of charges hearing has been held. There are no new facts that have emerged that would undermine the legal or factual findings in this chamber's last decision on detention. There is absolutely no basis for modifying the earlier ruling. Your Honors, the purpose of periodic review under Article 60, subparagraph 3, is to assess whether the conditions under Article 58, subparagraph 1, as required by Article 60, subparagraph 2, continue to be satisfied. As the Appeals Chamber has made clear, this review is not limited to newly submitted material. Rather, it requires the Chamber to consider the totality of these current circumstances and to satisfy itself that continued detention remains necessary. In this case, the conditions under Article 58, subparagraph 1, A and B, remain firmly in place. We wish to emphasize that the Appeals Chamber has recently reiterated that pretrial chambers are authorized to assess the likelihood of future events. The question before this chamber is not whether interference is inevitable, but whether there exists a real possibility of such occurrences. On the present record, that possibility remains very strong. We wish to reiterate that there has been no material change in circumstances that support the entitlement of Mr. Duterte to an order releasing him from detention. On the contrary, the current procedural posture heightens the risk of non-appearance. As the proceedings advance, the suspect's incentive to flee increases. The end of the confirmation of charges hearing, which occurred today, further intensifies that risk, as it brings the prospects of trial nearer on the horizon. Additionally, the conclusions of the panel of experts that Mr. Duterte is able to follow the proceedings underscore rather than diminish the risk. His capacity to understand and participate necessarily implies a capacity to assess his situation and act upon it, including the possibility of absconding. It must also be recalled that the appeals chamber has also found no error in the chamber's previous determination that Mr. Duterte has demonstrated a propensity to interfere with investigations. That assessment remains unchallenged by any new evidence. No intervening developments have displaced it. Moreover, Your Honors, this chamber found and the appeal chamber affirmed that Mr. Duterte benefits from a network of supporters capable of facilitating his flight. The existence and nature of such a network are not circumstances that are easily altered. No information has been presented that would suggest this support structure has dissipated or disappeared. Consequently, the risk of flight remains very substantial. With respect to Article 60, subparagraph 4, the chamber must consider whether the overall period of pretrial detention has become unreasonable, and if so, whether any delay is attributable to the prosecutor. Mr. Duterte has been detained since March 2025. However, given the gravity, the complexity, and the wide scope of the charges, the duration of detention is not unreasonable. Furthermore, there has been no inexcusable delay attributable to the prosecutor. The record does not support such an assertion. Finally, Your Honors, the position of victims and witnesses is a highly relevant and a significant consideration in this regard. The information provided to us by victims has always been consistent. They express genuine fears for their safety and that of their families should Mr. Duterte be released. The victims have articulated concerns about renewed instability and intimidation in their communities, particularly because of the holding of the confirmation of charges hearings. Therefore, we cannot stress enough the duty of the chamber to not only safeguard the rights of the suspect, but also to ensure the integrity of the proceedings and the protection of victims and witnesses. On the present record, releasing Mr. Duterte would create risks that the statute seeks expressly to prevent. Madam President, Your Honors, in light of the absence of any changes in circumstances that supports Mr. Duterte's release from detention, the continued existence of a significant risk of flight and interference, the advanced stage of the proceedings, the reasonable duration of detention to date, and the expressed concerns of victims, the participating victims respectfully submit that Mr. Duterte's continued pretrial detention remains both warranted and necessary. Thank you, Your Honors.
Judge Motok, thank you very much, counsel. We can now move on to submissions from the defense. Mr. Kaufman, you have until 1500, well, past. We've moved on.
Your Honours are aware, the defence has appealed the pretrial chamber's decision on the first detention review, that's number 357 in the case record, And since we are still awaiting a judgment of the appeals chamber, the defense will not oppose the continuation of Mr. Duterte's current detention. Thank you.
Judge Motok, thank you very much. Mr. Kaufman. So we're still speaking about 1,500 hours. This concludes the hearing. The submissions will be taken into account when the chamber makes a decision regarding the continued detention of Mr. Duterte. That decision will be handed down within the deadline set within the rules of evidence and procedure. Once again, I thank the participants, the parties, interpreters, court reporters, and all other staff members who have helped run this hearing. The hearing is now adjourned.
Thank you. That was shorter than expected. The second hearing that took place this week was the hearing on detention. We got a commitment from the presiding judge that they will decide on the motion within the rules allowed by the International Criminal Court. Unlike the decision on the confirmation of charges, that will be within 60 days, right? I think we will be able to get correspondent Michelle Abad live. We're just working out the connection. We did talk about this, right? So this is a periodic review. Did the confirmation of charges hearing have an impact on this, on the detention issue?
As far as the proceedings are concerned, they have no really direct connection in terms of like the proceedings itself, but there could be on the result of the trial. For example, Attorney Tente mentioned that last Monday that if the confirmation of charges went in favor of Duterte and the chamber did not confirm any of the charges, the chamber could actually order the release of the former president if they see no reason on the part of the chamber to hold Duterte under their custody. But so yun yung dun siya connected in that way. But again, we're really looking at three instances, at least on the confirmation of charges. Okay. We're looking at the confirmed lahat, or may confirmation kahit isa. If there's a confirmation, even one confirmation, then Duterte will remain under under the custody of the chamber. And the second instance is wala talaga, yung no confirmation at all. In that case, the chamber could order Duterte's release from the chambers or from the detention under the ICC. And the third, the middle, is the limbo. Deferral ng confirmation, hindi mo na confirm. The chamber might order the prosecution to review their evidence, or the chamber could say na, your evidence does not or do not fit this charges. So maybe you may want to review your charges. So in those instances, if we're gonna look at those instances, the probability of Duterte being released is actually low, because the probability or the possibilities are more are in favor actually of the prosecution and not much on Duterte. So yun yung relationship nila.
I want to go back to the closing statement of the defense, no? Nicholas Kaufman. Earlier we discussed that he's actually chipping away at some of the arguments, right? I mean, we should not underestimate his performance. But what was the purpose of that second half of the closing statement? No, I don't think it was addressed at all to the judges. Like, portrait of a weak and diminished and uninterested former president. Kawawa naman.
What was he?
In more simple words, politics. If we're gonna look at how the ICC detention of the former president benefited his family, let's take a look at the 2025 elections. I was in Davao for a considerable number of weeks. I interviewed people there, and I talked to a lot of sources, to politicians, human rights organizations, and even to ordinary people. And they told me that, you know what, Gyro, if the arrest did not happen, Nograles has actually a chance to beat Duterte's son in the mayoral race. But then again, this detention was actually like a force majeure in the local politics. And we saw how these, Duterte kawawa naman narrative translated into a political sweep, into a political boost for the family of the former president. In fact, five of his family members are now in office. 4 of them won in the 2025 elections. They swept the local politics or the local elections in Davao City. And we're looking at the same pattern here in the case of Sara Duterte, who, just announced her presidential bid for the 2028 elections. And the ICC proceedings are here, and it's no accident that Sara announced his presidential bid just days before the confirmation of charges hearing.
So,
that's why for me, in my opinion, that is really the purpose of Kaufman's last part of his speech.
Politics. We're very happy to have Michelle Abad back and live reporting from the International Criminal Court. Hi, Michelle.
Hi, John. Yes, it's been quite an emotional, I would call, end to the session for the day. I would like to highlight especially some might say it was the most notable part of the last session of the merits when Attorney Nicholas Kaufman talked about how he visited the former president in prison. He talked about how, first, the language that he used about the journalists who literally mobbed him yesterday to ask about how the former president is doing, and how he has been reacting to the hearing so far. And he did create quite a narrative account of what he and the former president had been talking about. He talked about he gave visuals of having a barong fitted for him, but that it would dwarf him with his current physique. They tried to engage him with videos, or I'm not sure about videos, but he tried to engage the former president with what was happening in the proceedings, trying to perhaps give some excitement to the president to react and to respond to the allegations that were hurled at him in the course of the past days. He narrated these supposed words from the former president, who told him that he should just do his job, go to court, and he was not interested anymore to follow the details of the proceedings. And so after this account of narrating to the former president of what happened, he said that he tried to humor him. He talked about his birthday, his 81st birthday being next month. He talked about the how many people are going to the so-called Duterte Street. He gave visual descriptions of letters from his youngest daughter, Kitty, piling up in his prison cell, and that there were lots of bouquets of flowers that were rotting in the corridors. So it was an interesting thing to see the attorney Nicholas Kaufman narrating these things. I was looking around for reactions in the public gallery. It was quite an interesting, and people were really paying attention to what Mr. Kaufman was saying, because of course it's been almost a year since we have seen the former president. So for his lawyer to be giving such descriptions, such visual, easy to imagine descriptions of how the president was responding to these confirmation of charges hearing, especially since he chose not to go physically, was something that most of the people in the room were really paying attention to. And there was also, that interesting moment when lead prosecutor, from the prosecutor's side, Mr. Nichols asked the pretrial judges to strike it from the record because it was supposedly not relevant to the merits, and that it was an appeal to emotion. And so it was an interesting thing to witness. It was a little more emotional and a little more dramatic, I might say, from the part of from the pretrial hearing as of today. As after the hearing, of course, we listened to the review of detention hearing that happened a few minutes afterwards, where both the prosecution side and the common legal representative of the victims did detail that new circumstances did make Mr. Duterte a flight risk should he be granted interim release, such as the fact that he signed a waiver that was this particular waiver that was waiving his right to be present at the hearings, and the fact that he used language that that indicated that he did not supposedly respect the court and its jurisdiction, that it was indicative that he would run away or abscond should he be given interim release, and that his network of supporters would really try and go out of their way and exert effort to make sure that Mr. Duterte would escape the jurisdiction of the ICC. So these things, we were actually not sure if they were going to, some of these things might make it to the broadcast, but we have heard that it was broadcasted to you, and so it was. We did try to go outside to see if the supporters of the former president were listening as well. We were personally, I was not able to interview anyone of the Duterte supporters side yet because everyone was waiting for the Duterte lawyers to come out and give their interviews and reactions. And it was just a big scene outside. I literally just come from there to come from you. So maybe since we're talking now, I also would like to ask about how you felt, watching this proceeding. We gave our point of view from the public gallery. Were there any reactions from the newsroom as well?
Well, I was struck by what Kaufman tried to do in his closing statement, especially the appeal to emotion, when he tried to do this act of verbal jiu-jitsu, taking the image of Joel Butuyan, the boat, this is the last boat that the survivors can board, and turning it around. And what did he say? This boat is the confirmation process, and the captain is this honorable bench, and how many sharks and rocks have we discovered? I thought that was astonishing, in its boldness. Parang the audaciousness of it all. Jairo, ikaw, what was your reaction? Sorry, go ahead, Michelle.
Go ahead, Michelle.
Ano lang, kasi din, yung na-point out lang din na sabi-sabi dito na, diba, Kaufman ended with the image of how he was showing photos of his children to him, diba, na from the kids to Inday Sara, talking to the people, and that, I don't remember the exact words, but it was to the effect na parang he lit up with joy, parang ganon. And I don't know, we can't, some of us, some off the record na medyo background information lang na sabi-sabi lang na naririnig lang, na it could be political, no? Especially since the vice president has just recently announced her bid for the presidency in 2028.
Sorry, maybe one or two more questions. What was the reaction of the media when Kaufman attacked the media again? Attacked both the victims' counsel and the media, saying what the counsel said, this is just a reflection of what the media is saying.
Actually, sa perspective ko lang, yung pinaka naging reaction na talagang nagtinginan lang kami was the language that Attorney Kaufman used na the journalist literally mobbed me yesterday. So, diba, it's the use of language na parang, diba, so we just looked at each other and we continue to listen kasi alam namin na magiging interesting yung susunod na sasabihin.
Interesting that choice of word, no?
And actually interesting the use of the word mainstream media, because normal people would just refer to media as media, but who uses mainstream media? It's Duterte. It's a wording by Duterte to highlight how these supposed mainstream media, allegedly run by oligarchs, are running after him and operating against him. That's a Duterte messaging.
Michelle, before we let you go, maybe one last question. What's going to happen now to the people who are there? Earlier, Lian said, going to the cafeteria, it's like you see a reunion of the human rights community, right? What's going to happen now? Are people going home? Are people going on the road to spread the word?
Well, kakakausap lang namin kay Attorney Salvador Panelo, kakalabas niya din, like literally a few minutes ago from us talking now. Tapos tinanong din namin siya, what's next, sir? At ang sabi niya, uuwi na kami. And yun yung sinabi niya. I guess it's just along the lines of satisfied na sila sa performance ng defense pagdating dito sa merits that would supposedly protect the former president from getting the charges confirmed. As for the victims naman, it's a continued dealing with a bunch of harassment. There's I think Lian talked about this earlier, na may additional security measures na silang ginagawa. In the past days, the Rise Up for Life and for Rights Coalition have usually been giving these little mini press cons outside the ICC after each day. At I think now parang they're making these little tweaks para hindi na sila magkaharap ng Duterte supporters. And so, it's that tension will still remain. We're expecting that tension to still remain, especially since most of the people who came here for the hearing might still be here tonight, diba? Kahit na natapos na yung hearing. So, aabangan din natin yan kung kamusta magiging experience ng mga victims for the next future.
Michelle Abad reporting live from The Hague. Thank you very much.
Thank you.
Jairo, what about you? You cover justice, you cover the EJ case and so on. After this very intense week, what's going to happen in your beat in the next month or so?
I'm really looking forward on how this will really have that, reverse complementarity principle. I hope that, the Marcos administration is taking notes. Let us just reiterate that the killings don't stop. Didn't stop under Marcos. The killings continue, and I hope Marcos would take measures to investigate this, show to the international community that he really is the pro-human rights president he thinks he is, diba? And that he will join the International Criminal Court because if he really wants to, leave a lasting legacy, a new legacy under a new Marcos, that would probably be, rejoining the ICC, investigating the drug war deaths, and prosecuting the policemen. And last on my part, I would just like to reiterate that this confirmation of charges hearing is only meant to, to assess whether there are enough evidence to push to trial. So hindi pa po ito conviction and all that. And number two, it's very important to highlight this case because for two things. One, for international jurisprudence, whatever and however the court, the ICC pretrial chamber will decide on this, it will go down into history. It's very important kung paano ma-appreciate ng korte yung mga ebidensya dito at especially on the issue of jurisdiction because it will affect other cases as well and future cases as well. And lastly, on that second part, for the victims, totoo yung sinabi ni Attorney Butuyan that this is the last vote for the victims. As as someone who has been covering and following them, this is really their last vote. We are at the International Criminal Court really watching our former president facing the chamber. Iyon ang dahilan. Ang dahilan nun ay hindi nag-work yung justice system natin. Hindi nabigyan ng pagkakataon yung mga mahirap na kababayan natin na pinatay yung mga kamag-anak nila na makakuha ng semblance of justice. Ito yung last chance nila para makakuha ng redemption at ma-reclaim yung dignidad nila at wag natin silang i-deprive of that right na makakuha ng hustisya para sa pamilya nila.
One thing I'd like to know is anong papel ng mga lawyers ni Duterte who came from the Philippines? Did they have a role to play? Did they even have an impact on Kaufman's arguments?
Yeah, as far as they're concerned, wala naman sa ICC rules na nagsasabi na hindi sila pwedeng mag-advise kay Kaufman, but hindi sila pwedeng magsalita during the proceedings kasi nandun lang naman sila in attendance as, as ordinary citizens and actually as visitors. As pointed out by Lian, actually yung treatment doon sa kanila, parang yung coverage nila sa Pilipinas, parang they made it appear na pupunta sila doon like a brilliant team of lawyers when in fact pupunta sila doon just like ordinary citizens, just like how the victims would watch the proceedings, just like how would journalists and human rights organizations observe the hearing. So technically on the mas sa political. Mas sa political messaging na itong si Digong, suportado pa rin siya ng mga Duterte men niya. Meron siyang 6 na lawyer, afford niyang papuntahin yung mga lawyers doon. More of like intimidation and just to show that, meron siyang backing ng mga malalaking pangalan katulad nila Panelo, ni Miguel Dea, et al.
The fourth and final day in the confirmation of charges hearing against Rodrigo Duterte has concluded. Will there be a trial? The presiding judge of Pretrial Chamber 1 said they will decide within 60 days. Rest assured that Rappler will continue to cover developments at the ICC. Many have contributed to the special coverage over the last week. Thanks to everyone. Thank you especially to our journalists on the ground, Leanne Buan and Michelle Abad in The Hague, and to Gyro Bolledo, who served on the panel for 2 days and anchored the panel for the other 2 days. And also thank you to Attorney R.P. Santiago of the Philippine Coalition for the International Criminal Court. Lian was able to sit down with Deputy Prosecutor Lian. Here is a sneak peek.
What does it mean for a case in the ICC that the suspect has said so many things about killing and creating his own death squad that is just for all of us, the world, to hear? Does that make you confident that you have the charges?
Yeah, I think that one of the peculiarity of this case, no matter what the defense say, is that, it's not always that you have like a self-confess, crime of this magnitude. And it was not, as the defense has tried at one point to show that, this was just a hyperbolic statements. But this statement meant nothing. So he would say that, but at the end of the day, he was a very law-abiding. We all know that he has tried and built a reputation out of this. So I think that in this regard, that shows also the word that when people think that they enjoy impunity, so they can also be, I think, that they're extremely confident. But and this is also an image that shows that, don't be overconfident, because the wheel of justice may be slow, but at one point they can catch up with you. And then all the statement you made, I think that, they will really be, in fact, your own evidence against you. And that's what we have witnessed also here.
Former officials of the Duterte government, and many of them are here, keep saying throughout this week that you are just desperate to keep this case because you have few cases going on. How would you want to respond to that?
No, but, okay, so I think that we are not desperate for cases. Whoever says that, he doesn't know how ICC works. So ICC, in ideal world, shouldn't have a case, because we are not here to trump or to supersede or to replace the domestic system. So first and foremost, no one wants these mass atrocities that make our jurisdiction. So we are only competent, it's war crimes, crimes against humanity, or even genocide. We don't want that to happen. So we can't be desperate for that to happen. Whenever we are called upon to intervene, it means first that mass atrocity have occurred. It also means that it has not been addressed locally, and then we step in. So we, in the case of Philippine, of course, we've stepped in. So there were litigation that it will be addressed domestically. So we have waited, and then we have litigated that when we saw that it was not properly addressed domestically, and then we prevail. It's only that because of that now we are fully embarked upon trying this case. Yeah.
The wheel of justice may be slow, but it will catch up with you. Watch out for the full interview on Rappler's YouTube channel. This has been Rappler's special coverage of the Duterte ICC pre-trial hearing. I am John Nery. Thank you, and may justice prevail.